Blog Talk Radio. Blog Talk Radio.
Peace to the gods. We had a little technical difficulties, so we're going to give everyone time to get in because we had to rebuild the show.
Welcome to Happy Hour on Venus Fridays with your host, Chief Bay on Hindsight Radio.
For the honeys, man. Mega booty call. Do something for the get high, honey, dog.
Welcome to Happy Hour on Venus Fridays with your host, Chief Bay, on Hindsight Radio.
Does the government work for us or do we work for the government? Is the best government really the one that governs the least? Can we ever have a government that stays within the confines of the Constitution? If the Constitution was written to keep the government off the people's backs, why is the government all over us? Tonight, whatever happened to freedom? Understanding where we go from here should start with understanding how we got here. We are the free and independent people of the United States of America. We are free because those who preceded us fought a war against a person who was then the world's grandest king and who presided over what was then the world's grandest empire. The Founding Fathers risked, as they like to tell us, their lives, their fortunes, and their sacred honors for the freedom and independence they won and we have inherited. But they were not saints. And initially, their cause was not popular. From the records available today, the people who measure historical trends have concluded that in 1776, only about one-third of Americans supported the revolution, about one-third of Americans opposed it, and about one-third of them didn't care. When I first looked at these numbers, I thought, in 1776, this was the grandest fight for the greatest amount of freedom for the most people at any point in history. So who could possibly oppose it? And who in their right mind could not care? Fast forward to today and ask, who could possibly support a government that regulates everything from the strength of the water pressure in your shower to the size of the toilet bowl in your home to the thickness of the leather in your shoes? Who could want a government that punishes people for speech, that lets its own agents write their own search warrants, that fights wars just to keep the military-industrial complex busy, that debases all you own by printing worthless money and putting it into the stream of commerce, that gives away more than half the tax dollars it collects, and that, despite express provisions in the Constitution to the contrary, permits the president to lock up whoever he wants and to throw away the key? Perhaps the colonists who didn't care if they freely chose their government or were cared for by a benevolent tyrant had an odd way of knowing what was coming. Perhaps those who opposed the revolution were afraid to take on the king, to challenge authority, and to risk their comfortable lives for the unknown. Well, we all know what happened. A relatively small part of the population pushed the culture and society toward freedom. And the freedoms that they chose were pure. I mean, after we won the revolution and wrote the Constitution, the new government and the political class assured all Americans that they could think as they wished and say what they thought and publish what they said, that they could associate or not associate with anyone. They could worship as they chose or choose not to worship. They could defend themselves with guns even against tyrants, that troops would never enter their homes, that only neutral judges would issue search warrants, and that the government could not take their lives, their freedom, or their property without a trial, at which their fault would be proven in front of a neutral jury. All this was guaranteed to the first generation of Americans and to their posterity, that would be us, because much of it had been denied them by the king and the parliament, and because Americans came to believe, even the one-third that were afraid and the one-third that didn't care, that these rights are ours by virtue of our humanity. Whether you believe that we are the highest order of natural selection, or whether you believe, as I do, that we were created by God in his image and likeness, you know in your heart that these natural yearnings, as St. Thomas Aquinas and Thomas Jefferson called them, are our natural rights, are a part of our humanity, and cannot long be denied us. And yet, they have been denied. The same Founding Fathers who wrote that Congress shall make no law abridging the freedom of speech, in fact, enacted the Alien and Sedition Acts, which punished speech that was critical of them, critical of the government. This happened because people were afraid to challenge the tyranny of the majority. America, the greatest losses to our freedom have come not from someone attacking us, but from the government ignoring the Constitution and the majority letting them get away with it. The worst amendments to the Constitution were not those ratified by the states, but rather were amendments by consensus, where all three branches of government agreed to look the other way. When good people do nothing, bad things happen. So what shall we do? We should challenge authority, no matter who is in charge. We should challenge the majority whenever it curtails anybody's freedom. We should side with freedom, no matter what the government says. We should vote out of office those who push the government outside the Constitution, no matter what earmarks they just brought home. And we should make the government afraid of us. Afraid of us. Because as Jefferson reminded us, when the people fear the government, there is tyranny. But when the government fears the people, there is liberty. From New York, defending freedom. Everybody's freedom whenever I can. So long, America.
About the USA? Do you know about the government? Can you tell me about the Constitution? Hey, learn about the USA. In 1787, I'm told our founding fathers did agree to write a list of principles for keeping people free. The USA was just starting out, a whole brand new country. And so our people spelled it out, the things that we should be. And they put those principles down on paper and called it the Constitution. And it's been helping us run our country ever since then. The first part of the Constitution is called the Preamble and tells what those founding fathers set out to do. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. In 1787, I'm told our founding fathers all sat down and wrote a list of principles that's known the world around. The USA was just starting out, a whole brand new country. And so our people spelled it out. They wanted a land of liberty. And the preamble goes like this. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America, for the United States of America.
Welcome to Happy Hour on Venus Fridays with your host, Chief Bay, on Hindsight Radio.
This one, baby. Fool for this.
I know what y'all want.
Yeah.
Me. 1, 2. Yeah. I'm doing my thing, I can't complain. All I'm focused on is to make it rain. $100 bills like the sky is falling in a $1 million movie starring me. And I'm from Harlem, home of some of the best that's worth recalling. Biggie Smalls used to visit here often. Even Jay-Z, is you crazy, Alvin? It's almost like the Apollo is calling. Many a star has fallen from falling out of control, like they name was Spalding. Even though I got soul, my money do the talking. Because I'm a risk taker, a dice shaker, make them dance off the gate of the bodega. Off the street, I get my paper. 4, 5, 6, see you later. Get off my dick, he's a hater. We got criminals and saviors. It's a minor thing, but we danger. Bought Harlem a diamond ring and in gangster. I'm doing my thing, I can't complain. All I'm focused on is to make it rain. Like the sky is falling, $100 bills in a movie starring me. And I'm from Harlem. Ill-a-coin is what the people call them. We came to party, but I beg your pardon. We don't want problems, but we can solve them. All of she's just another part of me. Like Mike Jackson, the ABCs of me rapping. I did it with passion from the beginning. I knew we'd be winning. Before the lights and camera, we had action. She kept me out of Rikers, unlike Pac and Wayne, John Depp. Just to get a rep, our struggle's the same. We maintaining, hydroplaning on the money while the cushies is out the painting. The sound of your chick complaining, she don't get the game and what it takes for you to make a name and get the check writers to make the payments so your music can make its statement. But what it takes most of all is patience, the hopes that all your works reach greatness. Success so close you taste it. Just focus on the hustle and you gon' make it. Just know that I'm doing my thing, I can't complain. All I'm focused on is to make it rain. Like the sky is falling, $100 bills in a movie starring me. And I'm from Harlem. Ill-a-coin is what the people call them. We came to party, but I beg your pardon. We don't want problems, but we can solve them. All of it.
Yeah, y'all know who it is, man. It's your boy Ron Browns, a.k.a. the Eat the Boy. Legendary, straight out of Harlem. Y'all know what it is, man. You listening to the New Wave 13, the album, Diggy Dime Music, Harlem. What's up? Yeah.
Hustle, yeah, tricks, niggas, pimp. Let me tell you about a place where I'm from. Harlem. Let's check it.
Hey yo, pimps, players, hustlers, tricks, niggas, bitches, everybody roll through the Harlem land.
You know,
a place you wanna go to,
where the spot is hot. Niggas get chased by the cops and women rolling flocks, pretty faces on every block. You know, 125th, shots ring out. You better stop and duck when bodies turn up on 12th Ave by the Cotton Club. Gangsters walk the street, toting guns in their back, cause shit's not what it seems. Some fiends smoke that real crack, so watch your back, cause these cats be acting retarded. And yo, fuck what you heard, this is where that crack started. Alpo, Richwater, AZ, had fame and glory. Yo, we paid in full, son. You know the name of our story. Summertime, the heat is on during Harlem nights. Deep in the project, families be looking for a fight. You know, mothers spaz on mothers and brothers cutting nephews, while aunts and cousins be looking for who else to step to. Harlem, a place where stars are born. Streets are shot up, a few niggas fell but never got up. Pimps, players, hustlers, tricks, niggas, bitches, everybody roll through the Harlem land. You know,
a place you wanna go to.
Pimps, players, hustlers, tricks, niggas, bitches, everybody roll through the Harlem land. You know,
a place you wanna go to.
Newport's is 750, but it's still the better city. Cops chase but never get me. I keep my Beretta with me, trying to get this cheddar quickly. Yo, it's like wherever with me. I'm trying to set it off. Is you trying to set it with me? Police stay in riot gear, cause we live over here. By any means necessary, Malcolm X die here. My niggas on 112th Street live by the code, no fear. And the cops will run up on you for drinking the open beer. Yo, these streets is kinda mean, you could lose your life fast. And those Jamaicans on 116th will put a knife in your ass. But on the other side of things, they got that mean green grass. But TNT will come through and do a clean sweep fast. You could lose your wife here, split in two like a knife here. Even if you in the right here, you could lose your life here. Start some shit in front of the kids, we could do it right here. Look into your eyes, son, you scared, but it's alright, who cares? Fuck with Harlem like Wes Craven, we be your worst nightmare. On Elm Street, you felt heat from my project there. Mike Tyson knocked the shit out of Miss Green. In front of Dapper Tans, you should've heard the chick scream. Shit was mean.
Players, hustlers, tricks, niggas, bitches, everybody roll through the Harlem land.
You know,
a place you wanna go to.
Pimps,
players, hustlers, tricks, niggas, bitches, everybody roll through the Harlem land.
You know,
a place you wanna go to.
Yeah, Harlem, baby. One of the many five boroughs, nigga. Manhattan. You know how we get down, son. We got mad history here. Y'all niggas come walk with us. No doubt, son. Get your hustle on in this motherfucker. You find the baddest bitches in this motherfucker. Yo, word is, yo. Y'all niggas come to the hood nigga Bravo. Let's get it poppin'. Step 2, chemical kick. Stop a motherfucking subliminal brick. Huh? Holla.
Welcome to Happy Hour on Venus Fridays with your host, Chief Bay on Hindsight Radio.
That don't make me the freak of the week.
Welcome to Happy Hour on Venus Fridays with your host, Chief Bay on Hindsight Radio.
What y'all thought y'all wasn't gonna see me? I'm the Osiris of this shit. Wu-Tang is here forever, motherfuckers. This 97, I ain't my niggas and my niggerettes. Let's do it like this. I'ma rub your ass in the moonshine. Let's take it back to 79.
I form atomically. Socrates' philosophies and hypotheses can't define how I be dropping these mockeries. Lyrically perform armed robbery, flee with the lottery. Possibly they spotted me. Battle scarred shogun, explosion when my pen hits. Tremendous, ultraviolet shine blind forensics. I inspect, view through the future, see millennium. Killer bees sold 50 gold, 60 platinum. Shackling the matches with drastic rap tactics. Graphic displays melt the steel like blacksmiths. Black Wu jackets, queen bees ease the gunson. Bumping with patrolmen, tear gas, lace the function. Heads by the score, take flight inside a war. Chicks hit the floor, die hard fans demand more. Behold the bold soldier, control the glow slowly. Proceed the blow, swinging swords like Shinobi. Stomp grounds and found footprints of solid rock. Who got it locked, performing live on your hottest fly?
As the world turns, I spread like germ. Bless the globe with the pestilence. The hard-headed never learn. This my testament to those burned. Play my position in the game of life, standing firm. On foreign land, jump the gun out the frying pan. Into the fire, transform into the Ghost Rider. A six-pack and a street car named Desire. Who got my back in the line of fire holding back? What? My peoples, if you with me, where the fuck you at? Niggas is strapped and they tryna twist my beer cap. It's court adjourned for the bad seed from bad sperm. Herb got my wig fried like a bad perm. What the blood? Clot? We smoke pot and blow spots. You wanna think twice? I think not. The iron lung ain't got to tell you where it's coming from. Guns are never owned, tearing up your battle zone. Rip through your slums.
I twist darts from the heart. Try to intrude, loop my voice on the LP. Martini on the slang rock, certified chatterbox. Vocabulary Donna talking, tell your story walking. Take cover, kid, what? Run for your brother, kid, run for your team. And your six can't rhyme groupies, so I can squeeze with the advantage and get wasted. My deadly notes reign supreme, your fort is basic compared to mine. Domino effect, arts and crafts, paragraphs contain cyanide. Take a free ride on my thought, I got the fashion. Catalog for all y'all that all praise due to God. The saga continues. Wu-Tang, Wu-Tang.
Olympic torch flaming, we burn so sweet. The thrill of victory, the agony defeat. We crush slow, flaming deluxe slow. War, judgment day coming, conquer, it's war. Allow us to escape hell, globe spinning bomb. Pocket full of shells out the sky, golden arms. Soon spit the shitty Mortal Kombat sound. The fake ball step make the blood stain the ground. A jungle junkie, vigilante tantrum. A death kiss, catwalk squeeze another anthem. Hold it for ransom, tranquilize with anesthesias. My orchestra, graceful, music ballerinas. My music Sicily, rich California smell. An axe kill adventure, paint a picture well. I sing a song from Sing Sing, sipping on ginseng. Righteous wax, chaperone, rotating ring March king. of the wooden soldiers, these cypher punks couldn't hold us. 1,000 men rushing in, not one nigga was sober. Perpendicular to the square, we stand gold like flare. Escape from your dragon's lair. In particular, my beat travel like a vortex. Through your spine to the top of your cerebral cortex. Make you feel like you busting up from raw sex. Enter through your right ventricle, clog up your bloodstream. Hot terminal like Grand Central Station. Program fat baselines on ovation. Getting drunk like a fuck, I'm ducking 5-year probation.
War of the masses, the outcome disastrous. Many of the victim families shake their ashes. A million names on walls engraved in plaques. Those who went back receive penalties for their acts. Another heart is torn, as close ones mourn. Those strayed niggas get slayed on the storm.
The track renders helpless and suffers from multiple stab wounds and leaked sounds that's heard. 93 million miles away from K1 to represent the nation. This is a gathering of the masses that come to pay respects to the Wu-Tang Clan. As we engage in battle, the crowd now screams in rage. The hot chief Jamel Ari takes the stage. Light is provided through sparks of energy from the mind that travels in rhyme form, giving sight to the blind. The dumb are mostly intrigued by the drum. Death only one can save self from. This relentless attack of the track spares none.
Yo, fuck that. Look at all these crab niggas laid back. Lamping lights in gray and black. Boom is on my man's rack. Codeine was tossing your drink. You had a navy green. Solomon the fiend. Bitches never heard you scream. You two-faced scum of the slum. I got your whole body now.
Ali. Came in threes, we like the Genovese. That's so these degrees is Earth. 93 million miles from the first rough turbulence. The wave burst, split the megahertz.
Hey yo, that's amazing. Gun in your mouth, talk. Verbal foul hawk. Connect thoughts to make my man chow walk. Swift notarizer, blue tank. All up in the high riser. New York gang visor. Word tranquilizer, just a dosage. Delegate my clan with explosives. While my pen blow lines ferocious. Mediterranean. See y'all, the number one draft pick. Tear down the beat guard. The delegate, the guard, the seagull. The swift chancellor. Flex the white gold tarantula. Track truck diesel. Play the weak guard. Substantial. Max mostly. Undivided then sliding. Sickening. Guaranteed. Made him jump like Rod Strickland.
Welcome to Happy Hour on Venus Fridays with your host, Chief Bay on Hindsight Radio.
Peace to the gods, peace to the gods, peace to the gods. I'd like to thank everybody for coming out to Venus Fridays with your host, Keith Bay, and your co-host, Rodney Bay. I got a really good show lined up for everybody. Today we're going to talk about part 2 of how to write a formal, or shall I say legitimate affidavit. But before I get started, I wanted to encourage everyone, if you haven't listened to this week's shows, you need to go back and you need to definitely check out Monday's show. Monday's show, Jonah actually went in on a United States code. The United States code is 28 USC, 1746, unsworn declarations under penalty of perjury. It was really hot when he dropped. I'm gonna tell y'all, I listened to the show myself probably about 3 times, but it was really good. And and I'm gonna piggyback on what he was covering, in this show also, just to give everyone a heads up. Started affidavit, y'all. Now, most of us, I'm pretty sure that's listening, I'm pretty sure that you're already familiar with the affidavit, or you pretty much already have an idea what an affidavit is. But what I found, in my studies, that sometimes it's best to go to the basics, and it's best to, read definitions on what these different instruments are. So that's what I'm gonna do, y'all. I'm gonna read the definition of an affidavit, and I'm actually coming out of the free dictionary by Farlex. If you go to Google, you type in define affidavit, you can easily follow me. I'm gonna drop a link to this in the chat room for everybody. All right, drop the link. Here we go, y'all. Okay, it says an affidavit. It says an affidavit is a written statement of fact voluntarily made by an affiant under an oath or affirmation administered by a person authorized to do so by law. An affidavit is voluntary made without, now, matter of fact, the subheading is distinction. It says an affidavit is voluntary made without any cross-examination of the affiant and therefore is not the same as a deposition, a record of an examination of a witness or a party made either voluntary or pursuant to a subpoena, as if the party were testifying in court under cross-examination. A pleading, a request to a court to exercise its judicial power in favor of a party that contains allegations or conclusions of facts that are necessary or not necessarily verified, differs from an affidavit, which states facts under oath. It says basis. It says an affidavit is based upon either the personal knowledge of the affiant or his or her information and belief. Personal knowledge is the recognition of a particular fact by either direct observation. Information and belief is what the affiant feels he or she can state as true, although not based on first-hand knowledge. The affiant. The affiant is any person having the intellectual capacity to take an oath or make an affirmation and who has knowledge of the facts that are in dispute may make an affidavit. There is no age requirement for an affiant as long as a person is old enough to understand the facts and the significance of the oath or affirmation he or she takes. The affidavit is valid. A criminal conviction does not make a person incapable of making an affidavit, but an adjudication of incompetency does. Someone familiar with the matters in question may make an affidavit on behalf of another, but that person's authority to do so must be clear. A guardian, and when they say guardian, that can be an attorney, y'all, may make an affidavit for a minor or insane person incapable of doing so. An attorney may make an affidavit for a client if it is impossible for the client to do so. When necessary, the duties a personal representative, agent, or corporate officer or partner may execute an affidavit that indicates the capacity in which the affiant acts. A court cannot force a person to make an affidavit, since by definition, an affidavit is a voluntary statement. Now, I think that's pretty hot, y'all. An affidavit is a voluntary statement. An affidavit is something that you choose to make when you state your facts and you choose to execute your administrative process. It's hot. Now, it says the taker of an affidavit. It says any public officer authorized by law to administer oaths and affirmations such as city recorders, court clerks, notaries, county clerks, commissioners of deeds, and court commissioners may take affidavits. Justices of the peace and magistrates are sometimes authorized to take affidavits. Unless restricted by state law, judges may take affidavits involving controversies before them. An officer cannot take affidavits outside of the particular jurisdiction in which he or she may exercise authority. The source of this authority must appear at the bottom of the affidavit. A notary, for example, will indicate the county in which he or she is commissioned and the expiration date of that commission. Now, that's very, very interesting what they just said, y'all. Now, for those who are not familiar with it, you need to go back to 1877 Georgia Constitution without any subsequent amendment. Now, what's very interesting about this Constitution, for anybody that's not familiar with it, I advise that you pull it up, you read it, you can Google that. Again, it's the 1877 Georgia Constitution. You can also pick it up, a certified copy of it at keithbay.com if you need one for your record. But the beauty about that particular Constitution, and I haven't seen this in any other Constitution, y'all. Now, I've read through many constitutions from many states, and the Georgia Constitution is the only one that I've seen that clearly states that a notary that a commissioned notary public is a court. A commissioned notary public is a court, y'all. A commissioned notary public is a court. Now let's read on. It says when religious convictions prevent the affiant from taking an oath, he or she may affirm that the statements in the affidavit are true. Now that's also an interesting statement because I know inside of the Bible, a lot of people. I know it's definitely a lot of Hebrew Israelites. They I actually heard a Hebrew Israelite brother actually state this before, but I know in the Bible it talks about how you're not supposed to swear. So, they always affirm, which me personally, I always affirm. Also, I affirm, that my yes means my yes and my no means my no, And then it goes on to say in context, it says there is no standard form or language to be used in the affidavit as long as the facts contained within it are stated clearly and indefinitely. Unnecessary language or legal arguments should not appear. It says clerical or grammatical errors, while to be avoided, are inconsequential. The affidavit usually must contain the address of the affiant and the date that the statement was made, in addition to the affiant's signature or mark. Where the affidavit has been made is also noted, and when the affidavit is based on the affiant's information and belief, it must state the source of the affiant's information and the grounds for the affiant's belief in the accuracy of such information. This permits the court to draw its own conclusions about the information in the affidavit. The affiant is strictly responsible for the truth and accuracy of the contents of the affidavit. If false statements are made, the affiant can be prosecuted for perjury. That's a serious charge, y'all, perjury. You never want to perjure yourself. You never want to give false statements. Now it says functions. It says affidavits are used in business and in judicial and administrative proceedings. In business, generally, affidavits are used in business whenever an official statement that others might rely upon is needed. Statements of the financial stability of a corporation, the pedigree of animals, and the financial conditions of a person applying for credit are examples of affidavits used in the commercial world. So they just told you that when you fill out a credit application, that's an affidavit. That's interesting. Now, it says judicial proceedings. It says affidavit serves as evidence in civil actions and criminal prosecutions in certain instances. They are considered a very, very weak type of evidence because they are not taken in court and the affiant is not subject to cross-examination. Their use is usually restricted to times when no better evidence can be offered. If a witness who has made an affidavit is not available to testify at trial, his or her affidavit may be admitted as evidence. If the witness is present, his or her affidavit is inadmissible except when used to impeach the witness's testimony or to help the witness with past recollections of facts. Affidavits are also used as evidence in ex parte proceedings, such as a hearing for the issuance of a temporary restraining order, which is an injunction, or in order to show cause. The expeditious nature of such proceedings is considered to substantially outweigh the weak probative values of the affidavit. In addition, there is normally a subsequent opportunity in the course of litigation for the opposing party to refute the affidavits or cross-examine the affiant. An affidavit based on knowledge of the affiant is accorded more weight than one based on information in the belief. Of course it will be. First-hand knowledge is always primary. First-hand knowledge is always before information and belief. And then it says, when admissible, affidavits are not conclusive evidence of the facts stated therein. Now, it says administrative proceedings. It says affidavits are frequently used in administrative and quasi-judicial proceedings as evidence when no objection is made to their admission and there's an opportunity for cross-examination. Now, I find that very interesting because to me, when I really read deep into what they're saying, this is how I perceive it, y'all. An administrative proceeding, pretty much an administrative process. When you write up an affidavit, right? Now, me personally, I like to write affidavit / contract. I like for my shit to be both, y'all. That's how I operate. So I like to use the elements not only of an affidavit, but I like to use the elements of the contract too, because I feel like it makes it that much more powerful. So not only do I have first-hand knowledge of the facts, y'all, not only are my statements, my foregoing statements, true and correct, but I'll make it in a sense, right? Well, like they say, how you can use it in an administrative proceeding as evidence when no objection is made to their admission. So, you serve it on them. You know how we mail it, notary presentment, send it over to the people. They don't respond, and when they're facing an offer, they have a duty to respond. You see, it has to be a duty, y'all. It got to be a duty for the person to respond. You can't just sit there and just write up a damn affidavit / contract and just send it to any damn body. It got to be somebody that caused you injury. You know what I mean? Somebody that's potentially causing you injury. It has to be some type of controversy between you and this individual, you and this person, before you can even execute this type of process on them. But this is what this is the beauty of it. You serve it on them. You know what I mean? You allow them the opportunity to cure. You allow them to speak up for themselves. That's a form of cross-examination. They decide they don't want to. You always stipulate inside of your document that silence is acquiescence, where you consent and agree to the facts stipulated herein. So then you got stipulated facts. So now when you got to take them to court, or if you decide to take them to court, if you have to take them to court, parties agree. Now you can stop them from arguing facts already adjudicated. Because again, a notary is a court. And a notary is who's authorized to administer the oath of your affidavit, y'all. And contract. Because remember, if it's under seal, if the contract is under seal, then consideration is not required. That's why I do affidavit / contract, y'all. Now, I'm gonna move on from that, and I'm gonna go to I found this article, y'all. This article is called "Legal Differences Between an Affidavit and a Declaration." I thought this was very interesting. I'm gonna drop a link inside the legal differences between an affidavit and a declaration. I noticed a lot of people, get those particular documents confused. It was once upon a time when I did too. You know what I'm saying? Also, I'm gonna give a special shout out to Brother Saji. Peace to the gods, Brother Saji. Peace to the God. Hold up, y'all. Also, peace, Brother Tom out in California. Matter of fact, Tom is having a and if you can, Tom, if you could press 1, sometime during the show, you can actually let everyone know. But I know you're actually having Jonah come out to California, Sacramento, if I'm not mistaken. So Everyone, if you can make it, please definitely check them out. I'm gonna tell you, Jonah's great on the radio, but he's 10 times greater in person, much better in person than on the radio. So, if you haven't had an opportunity to see this brother speak, I advise you to, if you can, contact, Brother Thomas, and get hooked up, fly out to Sacramento, y'all. Give me 1 second, y'all. Let me see something. Sure. I got a question coming out of the chat room, y'all. Normally, I do the questions later, but let me get the article. I think this is a good question for me to answer right now. And someone in the chat room is asking me what article inside of Georgia Constitution states that a notary is a court. So before I move on with the article that I was referencing dealing with affidavits and declarations, let me answer this, because I'm pretty sure it's other listeners is probably wondering the same thing. One second, y'all. My computer was fine at first. I'm like, this is wild, Open up another tab and difficult time for it. But I tell you, I mean, it's hot again. I haven't seen no other constitution that clearly states this, y'all. And it's taking too long. Let me try my cell phone, y'all. Let me see if I can put it up on the cell phone. My backup plan. All right. Here we go. Let me go with cell phone power, y'all. It's crazy. Okay, here we go. It's Article 6, y'all, Judiciary of the 1877 Georgia Constitution, and you want to look at Section 1, Paragraph 1. It says the judicial powers of this state shall be vested in a Supreme Court, Superior Court, Courts of Ordinary, Justices of Peace, Commission, Notary Public, and such other court as has been or may be established by law. So let's read it again, and I'm going to take everything out, and I'm just going to leave Commission, Notary Public in. It says the judicial powers of this state shall be vested in Commission, Notary Public, and such other courts as have been or may be established by law. So they just told you that the judicial powers of that state, some of the judicial powers is in Commission, Notary Public. The same way it's in your state, my state, all of the states, y'all, they all operate the same. It's just some constitutions, state certain things clearer than others. A notary public is a court in your court. A court in your state as well as mine, as well as in the state of Georgia. So, just wanted to cover that. All right, here we go, y'all. Drop this in the chat room. And all right, here we go. It's in the chat room. All right, here we go. It says affidavits are written documents attached to an oath or some affirmation, i.e. a notary public, that the statements in the affidavit are true. It says declarations are mere written statements that the author believes to be true, but the statements are given without the author being sworn in by a court officer. Declarations under the penalty of perjury, sometimes referred to as sworn statements, are similar to affidavits. Courts consider both to be legally equivalent, though most court systems and businesses still prefer affidavits over declarations. So the only difference, basically, what it's saying to me is that an affidavit has an oath or affirmation that has been sworn to or affirmed by a notary public or by some type of authorized public officer. And then it pretty much says a declaration is a statement. Everything is the same. So you have, it's sworn on the penalty of perjury. You have, the statement where you're saying that you have first-hand knowledge of the facts and that the foregoing is true and correct. But the only difference is that you don't have the notary seal on it. So that would be a declaration. That's the difference. Now, it says signature requirements. It says affidavits are signed in front of a notary public or commissioner of oaths and require notarization. Declarations must be signed only by the author and sometimes before justice of the peace or at least legal counsel. Then it says USC Code 1746 permits an individual to submit as true a declaration under the penalty of perjury. Now, U.S. Code 1746 is exactly what Jonah was covering in Monday's show. And that's where it talks about, matter of fact, I can read it real quick. It says, whenever under any law of the United States or under any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidenced, established, or proved by the sworn declaration, verification, certificate, statement, oath, or affidavit in writing of the person making the same, other than a deposition or an oath of office or an oath required to be taken before a specified official other than a notary public may, such matters may, with the like force and effect, be supported, evidences, established, or proved by the unsworn declaration, certificate, verification, or statement in writing of such person which is described by him as a true under penalty of perjury and dated in substantially the following form. And that's when he was reading how, prior to Monday, all of us actually were having documents or affidavits notarized within the United States because we didn't clearly state that we were without the United States. And then it goes into like number one, if executed without the United States, I declare or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. And then you gave the date that it was executed plus the signature. And then number two, state if it's in the United States, its territories, possessions, or Commonwealth. Then it says, I declare, certify, verify, or state under penalty of perjury that the foregoing is true and correct. And that's if it's in the United States. So you have to clearly tell them, or you have to clearly use statement number one to be without the United States, and even sign and even put without the United States next to your signature. Again, I highly advise anybody that has not heard the show. Matter of fact, you want to go back to last Friday's show. We had part one of Attacking Affidavit. You definitely want to check out Monday's show, and of course, you're listening to this right now. Now, go back to the article, and they say wording. Wording pretty much is the same. We pretty much covered the rest of that, y'all. Now, let me go to Attacking Affidavit, y'all. So we got the technical requirements of a sworn statement. Again, it has to be you have to take the declaration in front of a notary public. You have to have a statement where you're basically stating that you have first-hand knowledge of the facts. You're stating that that what you're saying is true, correct, and complete, and you're also swearing or affirming under penalty of perjury. That's pretty much what we covered last week out of this article. Now, this is another part that's important too. Now, I'm gonna put a link to this. Let me put a link inside the chat room, just in case. All right. Let's put a link to this for y'all. Okay. Now, if you go to Google, y'all, anybody that's not in the chat room, if you go to Google, you type in Attacking Affidavits, you want to go to the first, should be the first link. And basically, it will say Attacking Affidavits maintained in the integrity of the process, to where I'm reading from. Now, I'm coming off of page 41 inside of the document, which will actually be at the bottom of page 3. It says sworn statements and affidavits must be consistent with prior submissions and statements. It says too often practitioners believe that they can correct or contradict prior testimony by way of affidavit and therein create an issue or fact. It says this practice often takes the role of advocate advocate a step too far and can undermine the integrity of the process. Where a party submits an affidavit to the court that contains information inconsistent with the party's prior deposition testimony or other sworn submission, courts hold that these contradictory affidavits should be disregarded as sham or competing affidavits. And then it gave some court cases. It says courts will disregard a subsequent affidavit as a sham, that is, as not creating an issue of fact for purpose of summary judgment in the event that it contradicts the party's own prior sworn statement. All federal circuits and most state jurisdictions have adopted the sham affidavit doctrine in some form. Then they gave case laws to substantiate that. Then it says essentially this doctrine provides that a plaintiff cannot submit an affidavit in which he alleges new or different facts from the previously asserted in an attempt to create a material issue for trial. In distinguishing between a sham affidavit versus one that merely corrects or clarifies an issue previously addressed by the party, some courts have developed the following considerations for guidance. Number one, whether an explanation is offered for the statement that contradict prior sworn statements. This is number two, the importance to the litigation of the fact about which there is a contradiction. And number three, whether the non-movement had access to the fact prior to the previous sworn testimony. Number four, the frequency and degree of variation between statements in the previous sworn testimony and statements made in the later affidavit concerning this fact. Number five, whether the previous sworn testimony indicates the witness was confused at the time. And number six, when in relation to summary judgment, the second affidavit is submitted. Then they gave case law to substantiate that. It says where a party submits a competing affidavit that attempts to create an issue of fact, the court may properly disregard the party's subsequent conflicting affidavit or sworn statement. Practitioners should avoid losing sight of their role as an officer of the court, allowing it to be subsumed by their role as advocates for their clients by submitting contradictory and competing sworn statements. That statement right there is for attorneys. That doesn't apply to us. We're not officers of the court. Then it goes on to say practitioners should attack insufficient submissions with motions to strike or objections. Now, it's really, really, really important for people to keep in mind that you cannot contradict your prior statements, y'all. So when you formulate your affidavit, you definitely want to make sure that your statements are on point. Now, I did want to get this announcement, and I appreciate you dropping that inside of the chat room. Also, King, tomorrow, y'all. Hindsight Radio is having the IRS tax webinar. It'll be tomorrow, December the 5th at 10 a.m. You definitely want to check this out, y'all. You want to learn how to defeat those IRS letters, the levies, the garnishments, all of that crap. The donation is $100, and you want to send it, and I'm sure you can send it via PayPal to Akeem, which is A as in Apple, K as in Keith, IEMB as in boy at me or maryedward.com. Or you can go to hindsightradio.commerce.com and you can register, y'all. I definitely want to check that out. Also, I do have another announcement. I actually meant to say this earlier too. But at keithbay.com, we actually have the Tinsley versus Peggy Laro from 1964. We will have it available. We have it in hand, but we will have it available actually by Monday. A couple of days, we actually will have it in hand where we can actually, start sending it out to, to anyone that needs it. So you definitely want to go to the website, check that out on the website. For anybody that's not familiar with that case is very important because it deals with sworn affidavit, which is the topic of which we're talking about right now. And let me give you, for those who are not familiar, let me give you a figure out of there. Let me give you the baddest statement out of that daggone case, y'all. Here we go. That's a good ass case. I'm pulling it up, y'all. This is taking so long. Nope, that's not it. Wow, I wish I was better prepared with that. You know what? I got the damn document right here. Paper. That'll be pulling up on the computer. Let me just grab the daggone certified document, y'all. All right. This is on page 4 of the actual court order. Here we go. It says the defendant's motion to dismiss for failure to state a claim unsupported by affidavit or depositions is incomplete because it requests this court to consider facts outside the record which have not been presented in the form required by Rules 12b-6 and 56c. Statements of counsel in their briefs or arguments while enlightening to the court are not sufficient for purposes of granting a motion to dismiss or summary judgment. I think that's hot, y'all. That's some hot shit right there because basically what it's saying is that if counsel do not have affidavits to support their claim for a case to be dismissed, then you can challenge that. You can actually put this case inside of the court and demand that the court takes mandatory judicial notice to it. Matter of fact, I will put it in as an adjudicated fact personally, and that's under Federal Rules of Evidence, Rule 201. I will put it in that way because that is an adjudicated fact. You know what I'm saying? So just wanted to bring that up, cover that, and let me see. My co-host is on. Let me bring my co-host in real quick, y'all. Rodney, peace to the gods.
Peace to the gods, peace to the gods, peace to the gods. What's going on with you?
Hey man, just chilling, man. I tell you, man, I'm like really tripping over, affidavit / contracts. I mean, it's kind of funny. I kind of wish I reworded the show, but it's too late now. I kind of wish I would have called it something like elements of an affidavit, but I know I did something like that similar before. I didn't have as much information on it as what we got now. You know what I'm saying?
Exactly. And affidavits, that they're like real important, and it's even in the Bible where you need an affidavit. So it's very important that they got off of the authenticity and the real structure of the affidavit. So that's why they pay attention to them sometimes, or sometimes they don't, depending on whether or not you have all the elements met, if the affidavit is important enough in the case.
You're right. Excuse me. I'm glad you said that too, because you just sparked the light bulb just went off when you said that, man. Because I meant to write this down in my notes to go over the 10 maxims of commercial law, because one of the maxims in there, and for anybody that's not familiar with it, all you got to do is Google 10 maxims of commercial law, and you want to read those 10 maxims. I'm gonna drop a link inside of the chat room, but number 9. I didn't mean to cut you off too, Rodney, but it just went off. Because when you brought up the Bible does cover. It said, all right, number 9 says sacrifice is the measure of credibility. It says one who is not damaged, put at risk, or willing to swear an oath that he consents to claim against his commercial liability in the event that any of his statements or actions is groundless or unlawful, has no basis to assert claims or charges, and forfeits all credibility and rights to claim authority. And then it says Act 7. It says the life and death of Stephen. The maxim is he who bears the burden ought to also derive the benefit. Now, I like that maxim. I like that legal maxim a lot, because it's just like investing money. He who bears the burden of investing money also should derive the benefit from his investment. It's the same concept. You know what I'm saying? I didn't mean to cut you off, but man, it just went off in my brain, man. I was like, shit, I better talk about that.
It definitely makes sense because that's how everything ties in. You know what I'm saying? So it is very, very, very important, even though we are taking it for granted, and it really ties back into what Jonah was talking about with that code. You know what I'm saying? That the one that people should listen to the Monday show where he was going in on that code 28. I think it's 1746, and it talks about how to be with or without the United States. But that's the same thing that you can put in your affidavit. You know what I'm saying? Once you really understand that rule, you can make your affidavits without the United States and turn it into a private affidavit to where they can't use those codes and stuff against you that's within the United States.
You're right.
You know what I'm saying? Yeah, so that's like a hot piece where you can do a combination of things with it as long as you understand exactly what it means.
Right. I agree. I'm kind of curious, man, with what all the listeners think, man.
Yeah. Hit them up and see what they're talking about for this. Yeah.
You know, let me go to 209-401. Peace to the gods. Question or comment? 209-401. Peace to the gods.
Hello.
Hello.
Can you hear me?
Yes, we can hear you loud and clear. Yes.
Oh man, this is Thomas, and I called back in on the other line because the phone blacked out, and I thought it died. How you doing, brother?
Pretty good. How about yourself?
Good, man. That was a really good read. It's okay. Is it okay time to plug the seminar?
Yes, definitely.
Okay, folks. I'll put my email and my phone number in the chat in a second. Jonah's going to be in Sacramento not this weekend, but next weekend. That's December 12th and 13th. It's 2 days. He's going to cover some various topics we're going to have him cover. And if you want to attend that, if you want to get information on that, send me an email to emancipacionsacramento@gmail.com. And in the subject line, enter the word info, and you'll get an email back, and it'll have all the details. And then if you want to talk to me, you can call me or just send another email. Put help in the subject line. Put your phone number. I'll call you back. So hope to see some of you there. It's we're already getting a lot of people, so get your tickets soon. Yeah, I think we're going to fill it up. I'm optimistic.
That's hot. I mean, one thing I could say, Thomas, is that all of the guests that you're hosting for would not be disappointed. You know what I mean? I tell you, every time we brought Jonah here, to Maryland and D.C., it has gotten larger and larger to the crowd every time.
Yeah, we're really looking forward to it. It's a nice facility. We have good, microphones and everything. Everyone's going to be able to hear him well and to see his computer screen and everything. It's right in downtown Sacramento. We blocked some rooms out too for people. 10 rooms. I forget somebody just sent me the information on that, but I'm sorry I don't have it handy this minute. So we blocked out like 10 or 15 rooms, I think. Now to get those rooms, you have to get those by Monday. They're going to hold those through the weekend. This weekend, that is. And so if you're interested in getting a room, it's getting close. I don't know if there's anything going on. You could have trouble getting a room there. So you may want to try to contact us soon about that. Okay. And I think it's going to be awesome, man. I can't wait to meet Jonah personally and to sit at his heels, man, for the weekend.
That's hot.
Yeah. So thank you very much, Keith, and everybody in hindsight.
Definitely. Okay. No problem at all.
Okay, brother, I'm out.
Peace.
Okay. Peace. Yeah, again, y'all definitely check Jonah out live, y'all, and definitely check out the webinar tomorrow. Now I'm gonna go to 615-582. Peace to the God. Question or comment? Six one five 582.
Yes, hello.
Hello. Peace.
Hello. Brother Key, can you hear me?
Yes, we can hear you loud and clear.
Hey, peace, brother. This is Brother Ed from Nashville, Tennessee. How you doing today?
Pretty good. How you doing, Brother Ed?
Hey, doing fine. What's up, Brother Rodney? How you doing?
Hey, what's up, brother? How's it going? Peace to the God.
Peace to the God. Everything is good. Got a great show. Picking up a lot on the affidavits and, doing some Googling while you were calling out the codes and stuff, and some pretty interesting stuff. I like that stuff. I like what you guys are doing.
Appreciate it. Thank you.
We got to continue to set the bar. We always trying to move the bar higher and higher, y'all.
That's what it's all about.
Mm-hmm.
Yeah, because really what the affidavit does is really like, because all roads lead to court. So whenever we taking these contracts into court and trying to do a declaratory judgment or a tort claim, whatever you're trying to do, and you saying that you set the process to these people and they didn't respond, once you get in court, the judge may just look at your process and see whether or not you have all the elements of an affidavit, because what you're suing for 9 times out of 10 going to be something either monetary or something that deal with some issue that we all have. So therefore, if they go to your process and check all the elements check all the elements of the affidavit, check the notary book, check everything that you're claiming that's making this an element of a contract in order to win your case, they may just pick through it and just be real technical. So therefore, it's very, very important, I believe, because I really changed the way I was doing my processes and affidavits and even lawsuits and even on motions. I actually add that same little code as far as under penalty of perjury under the laws of the United States of America. You know what I'm saying? So therefore, once you do that, you're automatically outside of the jurisdiction of the corporation United States. So therefore, we won't be speaking in a double tongue the way Jonah says, as far as putting our paperwork in, but then at the same time accepting the jurisdiction by not doing the proper under penalty of perjury. So I think it's very, very important now that we're moving to the realm of suing.
That's real.
Right. Yeah, I agree. I got a question that's kind of similar along those lines. It might be opposite about a little bit, but when you use here in Tennessee, we have a constitution, of course, and Georgia's got one of the best constitutions I've seen in terms of the simplicity of what's being stated and stuff. And finishing up my injunction, and want to get some lines from the Georgia Constitution and want to add it under the supremacy clause. I was just trying to get just a little clarity on how to add that to my injunction. I know I need to get a certified copy, which I think I've ordered from you guys. Is there like a certain wording that needs to go into my injunction pointing to that Constitution, or what do you suggest is the best way to use the supremacy clause?
Got you. Actually, I'm actually trying to pull up Maryland Constitution right now, but it's actually a clause in Maryland Constitution. Matter of fact, it's in the Declaration of Rights. I know it's Article 45 of the Declaration of Rights. I'm trying to put it in front of me so I can read to you what it says. It's pretty much the same thing in the federal Constitution too. And I guarantee you, your state constitution, you can find exactly what I'm about to read to you.
Okay. Probably need to hear it so I can compare it to Tennessee, because we've looked at Tennessee and it's probably in there. It's just not worded as simple as some of the other ones.
Right. I'm pretty sure it's in there because most of them I've seen have this clause in it. But I want to read it to you exactly how they write it. 45. Okay, it says the enumeration of rights should not be construed It says this enumeration of rights shall not be construed or to impair or deny others retained by the people. So that clause right there pretty much is saying that there's other rights that is not necessarily enumerated in this Constitution, because all of these constitutions are codified constitutions. When you get a chance, you might want to Google define Constitution, and I would go inside of Wikipedia, because Wikipedia breaks down the difference between codified constitutions and uncodified constitutions. A codified constitution is a single embodied constitution, which will be like your state constitution or like the federal constitution. The only way to decode these constitutions is to read multiple constitutions side by side. So me personally, I would read like Maryland Constitution with the federal with Georgia with Florida. You see what I mean? Because this is how you obtain more information on how all of these states operate. Because all the states of the Union function and operate the same.
Right. Right. I got you.
You see what I'm saying?
Yeah. Yeah, I got you on that. So
now, let me ask you this. Which one of Tennessee's constitutions are you using? I know it's like 1834 and I think 1879.
The one right after the Reconstruction. This is 18. I don't have it in front of me. It's 1870 or somewhere around there. It's one right after the Reconstruction.
Okay. I'll
see if I
put it up real quick. 1879.
Yeah.
Let's see if I can pull it up real quick. So I can give you a more direct answer. Okay. Wow, they got this one really small. Oh man, here you go right here. I found it that fast. See, once you know what words, because I mean, all of them are worded very simple. But once you know what words to look for, you can easily go through the Constitution and just locate what you're looking for. I'm actually in Article 1, the Declaration of Rights, in Section 23. It says, this enumeration of rights shall not be construed to impair or deny others retained by the people. So again, that means that it's other rights that the people have, which is you, that's not necessarily enumerated word by word verbatim in the Constitution. Okay. That's actually what I used in my injunction to bring in Georgia Constitution when I actually did the same thing.
I got you. That makes sense. So basically, make that point to that statement in your injunction, and then you just attach the Constitution that you, like I would attach the Georgia Constitution along with that with the injunction.
Correct.
Okay. I know I was missing. There was one little simple piece I was missing, but that helps clear it up a little bit.
Right. Yeah. Now it's no problem. Because see, you got to remember, you got to keep in mind. That's like, even if they wanted to challenge you on that, you got to keep in mind what Article Section 1 of the Federal Constitution says. It actually states that full faith and credit is given in each state to the public acts, the records, and the judicial proceedings of every other state. So that means that you are able to use other state constitutions in your state. Now, the rule, matter of fact, the act is 1790, and this was the act. If I'm not mistaken, I think you brought it up last week, Ron. It was last week or the week before. But the act of 1790 actually goes into the method of how to do it, and that's where you find legislation like Rule 44, where Rule 44 talks about the means of proving an official record. They basically say when you get the record from the custodian of that record, and you have the legal certificate saying that this came from their archive, then it has basically full faith and credit of the United States. So as long as you have the actual Constitution, you got it, certified or even certified and attested to, then you're guaranteed full faith and credit of that instrument. So you can use it in any state. You just want to make sure you can defend whatever you do. That's really why I'm saying this to you.
Right. Yeah, I got you. I'm with you. You don't want to overkill and don't know what it is because there's nothing magical about it. You just got to know what it is.
Right.
Exactly.
That's simply all it is. Yep.
Yeah,
and
that's
the full name of that act is actually called the May 26, 1790 Act. That's the name of the act, May 26, 1790, and it's going to provide the mode by which the legislation acts of all other states and the judicial proceedings of other states can have the full faith and credit. So if you have to defend it, even in a court or something like that, you can have the court take judicial notice of that fact. You know what I'm saying? Because you have followed the full faith and credit of the Constitution, and you also followed the Act, which is general law. It's a statute at large that actually provides the way for you to obtain full faith and credit. So in other words, you just can't go to court and say, "Hey, Your Honor, I want to use the Georgia Constitution because it says a notary is a court, and Article 4 says I got full faith and credit to use it." You know, he's gonna look at you. He's not gonna tell you what we're telling you. He's gonna say, "No, you don't," and keep it moving because you haven't read the second part, and most people haven't. You know what I'm saying? Because and actually, I was one of them because I tried to use the Trinity versus Pagliaro like a year and a half ago and wonder why it didn't work. You know what I'm saying? So I thought it had full faith and credit, but it did not because I didn't present it properly to make the courts take mandatory judicial notice because now they have to follow the Constitution and the laws thereof, which is that statute at large.
That's real. Yeah, that statute of laws is general law. You know what I'm saying? And they told you it says general law that's prescribed by Congress. It's a general law that applies to the whole population. You know what I'm saying? And I wanted to throw this out there too. Those certified documents are contracts. They are contracts. They're under seal. It's a contract between people and the state, or or the federal government. You know, it depends on type of constitution you have. But all of those, they're contracts. You know what I'm saying? We went over the elements of a contract. It's the same thing. All you got to do is accept it. You see what I'm saying? Make yourself a party to the contract.
That's why the same law in Georgia Constitution, it says that you can sign on to the laws that you want to use, and the ones that you don't want to use, if you don't sign on to them, if it's special law, it's unconstitutional. You know what I'm saying? So that's another part of the Constitution that you can bring in there and make them take judicial notice to, because they took an oath of office not only to uphold the Constitution, but the laws of the United States of America, which is that statute at large. They have to abide by once you bring it in properly.
That's real.
And that's because they took an oath.
You know what I'm saying? Does it make sense?
Yeah, because they did take an oath to uphold those things, so you got to hold them accountable for their actions and what they do.
Absolutely. Now they may have an attitude, but I don't go to court to see if the judge is in a good mood or trying to see if the judge had sex the night before and feel real good. I don't care about his feelings. I'm not trying to be his friend. My job is to move the court. So yeah, he may be mad because I'm making him do his job, but it is what it is.
Yeah, I understand.
Because a lot of attorneys used to tell me back whenever I was an infant, it was you have to make sure they're in a good mood. I don't want to make them mad, piss them off. I don't want to do this. Yeah, I don't even care about all that. All you want to do is just be respectful and move the court.
Yeah, I understand.
That's real.
Yeah, but I've had a situation where the judge had a bailiff take me out of court and pick me up and drag me all the way in across the bar. So
absolutely, yeah.
So I've been through that. I've been through that road, so I know what you mean.
Yeah, exactly. Exactly. So you can go. You only make a difference. You can go into the bar, do whatever you want to. They still got to follow the Constitution. I don't even know what that crap means. Going inside the bar and all that. I don't care. I'm going with the Constitution. I can sweat. You know what I'm saying? So it don't even make a difference. So I don't even play with that foolishness. You know what I'm saying? Don't cross it. Don't say this. Nah. You got a job to do. You got the Constitution to follow and the laws thereof. You even go do it on the suit. That's how I'm going. I don't even care about it.
Is it fair to say that you don't give a damn about that shit, man? You know what I mean? You know what I'm saying? When you study enough and you get out here and start applying that shit, I mean, especially for the newbies, you're going to get like that. Like, man, because you know the difference between rights and privilege. I got rights. You know what I'm saying? I don't give a damn about how that judge feel or what he think. None of that. I'm not here for your fucking opinion. I'm here for you to rule with the force of law. That's what I'm here to do.
Your job. You know, your job is to rule on the facts. I'm giving you stipulated facts. You apply the law. I'm not here to practice law, so don't ask me no legal questions. You know, here go the facts right here. And here go my law to support my facts.
Right. Yeah, it's a strong piece that we learned from you guys is accepting the oath of office, because since we started doing that, so we see a whole different attitude when we go into court, and they know we have the oath of office and we accept it on record.
Right, exactly. Accept it on record. You know, I used to want to like collect that oath of office and say, yeah, I got your oath of office, I accept it. I don't even care, because I know the Constitution say that if you up there in a black robe making decisions about my life, you took an oath of office. So if you don't have an oath of office, you know, everything you say is a null and void. So therefore, if you're up there on a bench trying to make some rulings, I'm gonna treat you as if you have a oath of office, and if you violate it, you're gonna have to say that you up there bullshitting without an oath of office. They're not gonna say that. So I don't even chase them if they have an oath of office or not. If you're up there with a black robe on, you got one. Because I'm gonna accuse you of it, because the Constitution says you have to have it if you're a judge. And if you got a black robe on, I'm calling you a judge.
Yeah, it makes sense.
You know what I'm saying? So,
that's real
so therefore, once you accuse them of violating their oath of office, you want them to say, nah, I was just bullshitting. I don't have no oath of office. You know, everything. They like to say that. Other than that, I don't even want to see your oath of office. If you up there talking, you got one. And I'm going to treat you as if you do, so you better follow the Constitution, even if you are faking.
Right.
Yes, indeed.
Right. That makes sense.
Other than that, you can peel the lid right up off of it. So it don't even make a difference whether they have one or not. You can make them act like they have one. You know what I'm saying? Because if they know they don't have one, they don't belong up there.
Yeah, that's true. That's true.
That's what I'm not saying it. The Constitution says it. I'm just following that, and I'm making them follow it.
Yeah.
It's all right there.
Whether they like it or not, they don't have to follow it. Because they're used to not following it now. You know, because everybody been bluffing and faking with these guns, so they know we ain't got to follow these niggas faking. They filing intent to sue, threatening to do this and threatening to do this, threatening to sue, and they haven't even done the administrative process to even peel off the immunity to sue them. You know, you can't even sue a judge unless you peel the immunity off. It's a administrative process to peel the immunity to peel off their immunity, so you can go straight after them. So therefore, you won't get locked up for trying to put a lien on the judge, and the judge got immunity.
Yep.
Yeah, it makes sense.
That's real.
That's pretty wild.
Man, I'm like this. They want to fuck your life up. You better get with the program and fuck their life up. You know what I'm saying? I'm being real about this. I don't give a damn about them or their family. I don't care if they on the street eating dirt, man. That's why I'm real talk.
That's what you're trying to do. What you're trying to do to us. So you know, ain't no nice game. Nice game. I got one last quick question, and then I'll get off because I know you have some other people on the line. I just want to get your take real quick, going back to the affidavits, about once you get an affidavit about certifying I guess will you be certifying the notary seal before putting it into a case? Because I've heard, that it's always good to once you have an affidavit, have it notarized and get it certified, and it makes it a stronger document once you understand what that is.
Correct. And I guess, are you asking why does it? I guess, is that the question?
Why does it, and also your take on it? I guess basically it would be why. Okay. Well, why does it?
Okay. Now, my take on it is I agree 100%, and it's not even the fact of me agreeing to it. It's the fact that you have to prove the notary to be real. You see what I'm saying? What can be proven must be proven. That's the legal maxim. So whatever you can prove, you want to make sure that you prove it. So how do you prove that the notary is real? You go get the document certified, or you could do something that I do, because I have a really great relationship with my notary. My notary actually gave me a copy of her commission. Her commission has the signature of the Secretary of State as well as the governor of the state of Maryland. So I actually take her commission and I actually give them a copy of her commission too. with the number, with her notary number, her commission number.
I got you.
You see what I'm saying? So I'm like, even if you don't want to take time, because sometimes, and I used to go down to the court and get all my stuff certified too, and that shit used to take forever, man. I'm gonna tell you, me personally, I used to hate going down there to Upper Marlboro doing that shit, and because of how long it would take. You know what I'm saying? And the light bulb went off one day. I'm like, damn, every notary has a commission. The same way, because the notary is officer of the court, right? The notary, in my opinion, really should be framing, put up their, their commission. They could put that up wherever they do business at. You know what I'm saying?
Mm-hmm.
That's like their business life. So when I get a copy of this shit, you know what I'm saying? To me, it's just easy. Let me tell you, I even send that shit with my notary presentment. When I mail my stuff notary presentment, I actually, when I send my true correct copies, I actually send it with a copy of my notary commission, so they automatically see my notary is real.
Mm-hmm.
You
that
know
makes
what
sense.
I'm saying?
Yeah.
I
That's
thought
hot
about
right
that.
there. Yeah, that's hot right there. I mean, you ain't got to keep going down there. I know in Maryland, they charge $1, I believe. They charge $1.
Yeah,
I was glad when you pulled that out your hat. I'm like, man,
right.
that saved time. Go down there dealing with the women with the nasty attitudes and paying your money to get them jobs authenticated.
Right. Hey, check this out, Ronnie. It got the seal of the state, not even just the seal of the damn court. It got the seal of the state. You just basically authenticated the shit. You know what I'm saying? So now you don't have to go to Annapolis. You know?
Yeah.
Oh.
Exactly.
Hey, King, what's up?
Peace
to the God.
Peace. What's up, King?
It's our King. What's going on?
Peace, man. Pretty good. How about yourself?
Doing good, man. I'm just getting on your show. I haven't been on your show in a minute.
Yeah.
I've been listening in, but I haven't gotten on,
Right. Yeah.
Yes. So I wanted to share something with you if you had time.
Definitely.
Did you listen to the Khalifa show yesterday?
I've heard a part of it. I couldn't tune in like I wanted to because of the children, man.
Okay.
Certain days of the week, man, children, man, they children. But now go ahead.
So I went to court yesterday. Right? I'm
right.
going through a divorce. I don't. Me and you never had time to talk about that.
Right.
But of course, the attorneys send all of that crap about what they want and all of that. So basically, I followed our process. I'm not going to keep you long. I followed our process. I did everything. I did my spiritual work. Basically, long story short, I went to the courtroom. I didn't even have to open my mouth. I got everything I wanted. No child support. No alimony. I got all my cars that belong to me in my name. She got to keep her house. And joint custody of my daughter. And didn't open my mouth to say nothing the whole time.
And I think I know why. And I think I know why. Because
you know why? Because I did the paperwork, but do you know what the most important part was? The spiritual work. That was the key. That's the key. I had people praying over me. My girl, she prayed over me the night before I went in. Then, I went and saw my spiritual advisor. He did some stuff for me. Took my baths, and I had my Malibu. I took me a couple of swings of Malibu before I went in there to calm me down. And, and you know what was funny? They never called my name. They never said my name once in that room.
Wow.
Just walked in.
That's hot.
And when they called her in, I just followed. And the judge never used my name at once. Now, only time I had to speak is when they tried to get me to swear on the Bible. And I said, excuse me, I don't swear on Bibles because in James 5:12 says you don't swear or you'll be judged or you'll be condemned. So I don't do that. That's against, God's commandment. And she said, I just need you to confirm. I said, yes, I can let my yes mean yes and my no mean no.
Yep. It's funny. That's exactly what I was saying earlier, too. Yep.
Yeah.
That's right.
So
I was
what I'm saying is I was fully prepared. I put that COL on the case too. We have redid it. Dwight had redid it. Jonah sent it to me, and I put that in on the case. I actually put an injunction on all of the judges, the clerk of court, the solicitors, and their successors. I put my injunction into the case as well. I did the authenticated birth certificate, all my affidavits that I rebutted everything point by point. When he sent me his work, I put no contract on that, mailed that back to him along with my rebuttals to every point. He had like 19 things on there. They were trying to get everything, basically, trying to get me to pay attorney fees and all of this stuff, And I just walked out there. I leave the situation with everything I had. So
that's hot, man.
I just want to let people know if you do the work and you study and you do your spiritual work, everything falls into place. You don't have to do a whole lot of talking. But my mindset was like, I'm not walking out of here without a victory.
Yeah.
So before, and of course she had to agree with it. She was saying yes, agreeing to everything. And then the judge asked her, "Well, are you coerced into this?" So, and I could see the judge flipping through all my paperwork, everything. She was just flipping through it. And she said, "Well, I'm inclined to agree with this. Just send the court a copy. Send him a copy. Never said defend it or anything. Just said send him a copy." And
that's
hot.
Yeah.
And because I put my DBA on the record too. So what I wanted to tell the listeners is how sometimes they don't want to take certain things. What I did was I split up my affidavits. The stuff that looked like their work, I put it on top and buried the other stuff on the bottom and handed it to them and let them clock everything in. So they were just clocking it in right there in front of me without questioning. Now, there was a point where I ain't never seen anything like this. I said, well, that's just, my work. He said, I don't know if I can file it. I said, well, under Rule 5, it says that, it still has to be filed regardless if it doesn't look exactly like the paperwork. Then she went ahead and filed it. See, a lot of people got to look up that Rule 5. And then coincidentally, Rule 5 is right on top of Rule 5.1, Constitutional Challenge. Yeah, if you go, it's buried in there. You see? But anyway, before I tune out, I want to let everybody know about the webinar tomorrow at 10 a.m. Eastern Time. It's a $100 donation. We got a few spots left. We got a good response. And we're going to be talking about tax levies, garnishments, and all of that, and how y'all can get yourselves out of these contracts that you fell into, And I'm going to actually be showing letters that I have gotten from the IRS with their response. So, on the letter that I actually used to stop them. So that's going on tomorrow at 10 a.m. Eastern Time. I'm gonna be starting on time too. So
that's hot.
All right, man. I just wanted to share that. That's what your listeners wanted to hear that.
We did, and I appreciate you sharing that, man. That was hot.
Sure. Congratulations too.
You know what? Another thing about that? Yeah, thank you. There's another thing about that. Under public law, when it comes to child support, a parent cannot make that decision for a child that they don't want it, because the court says they look out for the best interest of the child. So the court has the leeway to make that determination themselves, even if that parent is refusing it.
Yeah, because
a lot of people don't know that.
Of necessity. You're right. The doctrine of necessity.
Right. Yep. So for me to walk out of there without it, even though she said she didn't want it, because I've seen guys they still force that. Said, no, you don't have the right to take the right to the child away. And because through the birth certificate that child is registered as a U.S. citizen, which is really not your child, technically, they get to make that decision for the child. So that just shows you the power of that paperwork. That she didn't even want to fool with that paperwork. So she just went ahead and agreed, and the judges signed off on all of that. See, a lot of people got to understand, man, they got to just go in there and study. Right. And it took, I was going back and forth there. I became a regular, knowing the daggone, the sheriff deputy, who, when you go through the metal detectors and all of that before you go in there, I was getting on first name basis with them. Saw me so many times. So
that's funny.
But that's what it takes. It takes work and diligence, and you got to do it in a timely fashion.
Yeah.
Yeah.
Yep.
No
doubt. Yep. That's it. Man, I appreciate you allowing me to share that.
Man, definitely. That was hot, man. That is hot.
All right, man. I'm going to mute out. All right.
Okay.
Peace to the guys. All right.
Peace to the guys.
Peace.
Yeah, that was hot. I tell you, man.
Yes, indeed. That's what hard work gets, dude.
Yes, indeed. Yes, indeed. I guess, Brother Eric, do you have any more questions?
Oh, that's Brother Ed.
Brother Ed. Sorry about that, Brother Ed.
Oh, no problem. No problem. I think I'm good. Brother Ronnie just wanted to let you know that I got my SEC audit back last week for the house.
Oh, you did? Oh,
yeah.
Okay.
Said that joint looked pretty too, with the blue ribbon and the full seal and stuff.
Yeah. Okay, cool. Okay, yeah. That's what's up.
Yeah, because the assignments, I went to the assignment and pulled that off public records and sent them a letter, and they verified the quote unquote owner of which was
the trust.
I think it was U.S. Bank, trustee of XYZ series, the whole thing.
Right.
So I matched up, and also matched up to my securitization on it. So I went and ordered from the SEC, and that came back. The certified copy came back last week.
Good. Now, what you ought to do, you ought to what I normally do. I used to order two of them. One I would read through and highlight, because there's certain sections of it that you can read and to verify even further your position of them not having the correct chain of title to make such an argument. You know what I'm saying?
Mm-hmm.
Okay. And then because that's also violating the like tax. That's why a lot of people used to do the 3949A on the trust because if they trying to double dip or trying to do something outside of the scope of that PSA, that's unwarranted.
Yeah.
Yeah. So that's good right there. We probably have to talk about it later on because there's a couple other little things that you can probably do just to add on to the information once you start going into the PSA and reading it a little bit.
Yeah. I went in and kind of skimmed a little bit. I know there's quite a bit to look through and just kind of fine-tune exactly what points I need to pull from it.
Right. Yeah, you can pull up. Yeah, you can pull it, and you also need to check the check the startup date. You know what I'm saying? Because inside of your PSA audit, it will let you know when was the last day all of the instruments were supposed to make it inside of the trust, and then what you do, you compare that date to the assignment of mortgage that's recorded in your mortgage, and 9 times out of 10, that assignment of mortgage is going to be after the cutoff date of that trust. So therefore, that's another violation for them. So it's just between that and other little violations that you can hang them up on whenever you start to do your administrative process. You'll have more ammunition, and then you'll have different types of discoveries to request under Rule 34, which is outside the discovery tactic. You can ask for discovery, and you're not even in court under Rule 34.
Okay, yeah. Actually, that date already got that date, and the date of the assignment of that deed is 2 years after that closing date. So that's already,
exactly.
I already know that's already a violation right there.
Exactly. And so now you have a record which is authenticated document, and it's self-evidencing under Rule 201 of the rules of evidence. You know what I'm saying? So that's good because you have the authenticated copy of it.
Yeah. So still got to start moving on that, and I'm gonna hit the law firm that's trying to do something. I'm gonna hit them in federal court on the FDCPA on Monday. Because some law firm just popped out of nowhere, and then they sent me one envelope, and then that same in the envelope, they let me know that they've been assigned to collect his debt, and in the same envelope, they gave me a foreclosure date, which I've never seen that happen before. I've never seen both those things in one envelope. I'm not even giving any to respond, so I sent them a letter, and I'm going to hit them with some FDCPA violations I found Monday and knock them off.
What state are you in?
Tennessee.
Yeah, you may have to file an action or something against them, and then request like an injunction inside of your action. So therefore, they won't be able to move forward until the outcome of the case, because you have questions with the validity of them trying to initiate or maintain that action.
All right.
You know what I'm saying? Because I'm not sure if Tennessee is a deed of trust state, or is it a mortgage state to where they have to file a lawsuit? Is it like a deed of trust state?
It's a deed of trust, and it's not judicial, so they just go to the courthouse steps. So I'm the one that has to initiate the lawsuit.
Okay, so that's what you have to do. But whenever you do, you have to come in with all your guns blazing and do a 5.1 on it. I would do both.
I was thinking about keeping them separated, hitting the law firm in the federal court with the FDCPA, and then starting administrative process on the servicer and finish that out on that side. Just keep them separated.
See, because a lot of times, I'm going to tell you a little secret. One of the things that we're going to do, we're actually doing a lawsuit with a securitization. And a lot of times it's not really the trust. Even though the trust may be appearing that they're owning it, a lot of times they're using the substitute trustees to bring the action. But most of the time, the substitute trustees purchase the debt because the trust already made the money off of the note back when you first got the note. You know what I'm saying? So whenever the trust was making all the money, you know what I'm saying, a lot of the services and attorneys, they start coming up to these trusts and how can I get in the game? And then whenever they start doing that, especially back whenever the securitization was real hot whenever the first mortgage crisis happened. What they was doing, they knew that a lot of the borrowers were unable to keep up with those payments. So therefore, they knew a lot of property was going to go to foreclosure. So to make a long story short, it's the substitute trustee that you should be suing, and what you ought to do, because once you sue him, he's going to have to stop bringing that action. And what you can do, you can use the evidence of the PSA to say, well, I don't believe that the trust would actually come and try to do a foreclosure action, and then you start naming all these violations, the tax code violations, everything that they would violate. So they say, I don't believe that they would do. I believe that the that the substitute trustees are debt collectors, because if you look at your paperwork, it's going to say that they're debt collectors, and then put all the weight on them and make them bring the trustee in. Bring the trust in and say, yeah, trust is really your property, and then the trust will be facing all those violations. The trust may not want to do that. Mm-hmm. Because it's actually the substitute trustee that's bringing the action, and most of the time, some of the stuff that we're starting to find out, that it's the trustees who pretty much buy all of these bad debt in the name of the trust, and it's using the trust as a vehicle in order to steal the property.
Oh yeah, I agree. Because like you said, the substitute trustees are these law firms and stuff, and they're the ones that are really creating damages, getting everything for pennies on the dollar. And this one right here doesn't even have the Miranda warning. It just says this is an attorney collecting a debt. So
exactly,
it doesn't even have a Miranda warning. So already within those letters, I already got 4 violations.
Right.
Just on FDCPA stuff.
But now it's time to bring an action because now they're trying to move on the property. So just line up all your ducks and just go in and sue and just ask for a declaratory judgment in part whatever lawsuit that you're bringing. Just to declare your rights as far as what they're doing, what the trust has done, and things of that nature, and then you can have them declare. And then therefore, once they declare the rights and all the violations that you found, that's going against your property, and then that will make them feel a different way as well.
Right.
You understand what I'm trying to say? Yeah.
Yeah, I follow you.
Yeah.
All right, well, appreciate it. Always good talking to you, brothers.
Okay, cool. No problem, bro. Appreciate it.
Yes, sir. So I'm going to get off and let somebody else get on.
Okay.
All right, great.
Thank you. Peace. Hey, Rodney, I'm gonna take a break. I know we thought at the top of the hour we're gonna do probably about a 10-minute break.
Okay, that's cool.
Yeah. All right, we'll be back, y'all.
All right, peace.
HindsightRadio.com. The information station changing the nation. Are you looking to discharge a public debt, do a non-UCC, set up a foreign trust, build estate credit, open a bank account, or do an injunction to protect your rights? Visit HindsightRadio.com. We have a variety of DVDs, templates, and a dedicated team to assist you in getting your remedy. We make networking easy. HindsightRadio.com. The information station changing the nation. Have you received a letter from a third-party debt collector? Have you been summoned for a court date? Is some corporation trying to infringe on your unalienable rights? Visit our contact information page to arrange a private consultation with a member of our team. HindsightRadio.com. The information station changing the nation. Tune in to Hindsight Radio every day of the week at 7 p.m. Eastern Standard Time and 6 p.m. Eastern Standard Time on Sunday. HindsightRadio.com. The information station changing the nation. Feel free to join in on the conversation. Call 914-338-0126. That's 914-338-0126. All callers may press the number 1 on their phone if they have any questions, comments, or information. HindsightRadio.com. The information station changing the nation. Visit our website for weekly schedules and more.
And this.
Joining our online chat is fast and easy. Go to blogtalkradio.com/hindsight2020 and create a login.
And this.
Tune in to the Jonah Bay Show every Monday at 7 p.m. Eastern Standard Time with your host, Jonah Bay. HindsightRadio.com. The information station changing the nation. Tune in to Truth Tuesdays at 7 p.m. Eastern Standard Time with your host, Akeem L. Tune in to Consultation Wednesdays every Wednesday at 7 p.m. Eastern Standard Time with your host, Jonah Bay. Tune in to the Temple of Commerce every Thursday at 7 p.m. Eastern Standard Time with your host, Khalifa L. Tune in to Venus Friday every Friday at 7 p.m. Eastern Standard Time with your host, Keith Bay. Tune in to the Sleep Sheep Show every Saturday at 7 p.m. Eastern Standard Time with your host, Uno Self, a.k.a. Dwight Bay. Tune in to The Bottom Line every Sunday at 6 p.m. Eastern Standard Time with your host, Joey Bounce L. Bay. Call 914-338-0126. Thank you. Hindsight Radio. Hindsight Radio. The information station. Changing the nation. Changing the nation.
When I want organic hygiene products, I visit naturalsomega.com. They have a variety of all-natural hygiene and healthcare products, ranging from body wash to toothpaste and more. The products are 100% organic. You won't find any of those harmful chemicals in any of the products at Naturals Omega. Visit naturalsomega.com at your convenience, 24 hours, 7 days a week. Naturals Omega is for the whole family. Visit naturalsomega.com.
Yo, it's that time of night. I gotta talk about Naturals Omega. Naturals Omega. Yo, is your hygiene up to par, man? Is the products that y'all using for your hygiene up to par? Do it got mercury in it? Do it got aluminum? Are you putting deodorant under your arms that's making you have cancer tumors? I'm talking about the men and the women. Yeah. Men, y'all catching cancer, breast cancer, from using deodorant. So are the women. Yo, it's no need for y'all to go through that anymore. Go check out naturalsomega.com. You can get deodorant and every other toothpaste, tooth powder, all these different things that y'all need for your hygienical needs. And not only is it going to keep you smelling fresh, it's also going to pull out those heavy metals, those toxins, those parasites out of your body and make you feel good, make you think correct. So check out Naturals Omega. All right? Yeah, she got some shit for your pores too. She got this lip scrub where it actually, pulls off the dead skin cells and reactivates the live cells and helps them, purify your body, make it nice and smooth, man. Like she used the lip scrub on her booty, man, and the booty's so soft, man. I can't keep my hands off the booty, man. Naturalsomega.com. Naturalsomega.com.
La música de Harry Fry.
Your love is poison. Every time I talk to you, darling, like you shoot me close. Every time I talk to you, like I was poison. Your love is poison. I couldn't die
Gotta pick your poison. Gotta choose. Gotta make some choices. I'm a new. Whatever works for your soul, yeah, I mean. I'm a new. Gotta pick your poison. Gotta choose. Gotta make some choices. I'm a new. Whatever works for your soul, yeah, I mean. I'm a man. Smoking that poison. Drinking that poison. Had to call them shots. Had to make some choice. Had to hit that block. Had to sling that poison. Had to hit that pot. Couldn't sleep every night. I was hearing them voices. Back to the wind. Didn't give me no choice. Left home with a dime. Drove back in a Royce. Your love is poison. Made me do it. Thought that fight stay broke. You was blue. Was trying to make you stay. Was trying to make your day. But the whole time you was poisoning me. Trip fake. With the lake. Crib up neighbor. Take know you poison baby.
Your love is poison. Every time I talk to you, darling.
you shoot me close. Let me talk for yourself.
Like I was poison ivy. I couldn't die
Gotta pick your poison. Gotta choose. Gotta make some choice. I'm a new. Whatever works for your soul, yeah, I mean. I'm a new. Gotta pick your poison. Gotta choose. Gotta make some choice. I'm a new. Whatever works for your soul, yeah, I mean. I'm a new. Ain't no poison, ain't no kill, positive, ain't no medicine. Fix that negative, that envy fake, pills and anger. Just a poison, cross the line and use the strength. Woke up this morning for some time. Woke up this morning for some time. I woke up this morning sometime.
The poison bad, you know what they say.
Woke up this morning.
Ain't no more poison can kill a positive thing. It ain't no more medicine that can cure a negative mood. Thank you. Coke boy, mac and cheese, appetizer. See you, bro.
Welcome to Happy Hour on Venus Fridays with your host, Keith Bay on Hindsight Radio.
Peace. Yeah, I want to take it. Peace. All right, we back, y'all. All right. Roddy.
Yep.
Okay, bad. The next call is for 570-730. Peace to the God, question or comment.
Hello.
Hello.
How you doing? Yes, God blessings and peace to everybody. How are you doing today?
Great. How about yourself?
Fine, thank you. Basically, I have a. Just want to say that I really appreciate everything that you are all doing at the Hindsight University. It's just amazing. But I do have one question that's a general question about the injunction. Is it it is recommended that I use the state constitution located in the state that I currently reside in, correct?
Correct.
Okay, and so if I'm looking at the Georgia Constitution, that's just a framework of what it's like.
Correct.
Okay, and the gentleman that was on a few moments before was talking about the I think I might have had it confused, general law and the supremacy clause.
Correct.
So I should be looking for the supremacy clause.
Correct.
Which is another section.
Right. You mean the clause?
Credit clause.
I beg your pardon?
It's the supremacy clause is Article 6, but we was talking about I think someone did mention the supremacy clause, but I think they was meaning the full faith and credit clause, because that's what we was talking about.
Okay. That's pretty good. Now, my next thing is a question. My question is this: are the brothers that are coming up with the fighting the child support thing, are they doing that because they question the child's DNA?
I apologize. I kind of missed the question.
I've heard a lot of very successful stories. Not just this one, but I heard one last week and the week before. A lot of the brothers are coming up, and they're dissolution of the marriage contract, and they're fighting the child support section of it. And I'm wondering if that's happening. Is that happening because they are questioning the authenticity of the DNA of the child, which they have every right to?
No,
okay.
That's not why. Why it's happening is because they're actually they're actually submitting affidavits and or declarations basically stating that the child pretty much is that the parent is before the child, and that basically the parent, or that they are the owner of the child. You see what I'm saying?
Of course, I own my car, but if I don't pay for my car, they're going to come and take it.
Correct.
Different
scenario, though.
Okay, different scenario. All right. Because it's giving the impression to me. It's giving me that this is the beginning of a disgraceful movement to remain solvent on paper, and this challenge to child support seems like a vile prima facie on its face, because it nurtures and it denurtures and disenfranchises the present and the future of the seeds they have dropped. I mean, that's just how it looks to me.
Right, and I'm gonna tell you, I actually respect your opinion. Now, I disagree with you because I'm gonna give you my story and give you my account. Now,
okay, because I just want to know why the brothers are doing it. Where they're coming from. I can respect where they're coming from if it's valid. So go ahead, tell me, what is it?
Okay. Now, I was one of those brothers at one point where I actually had my child support case dismissed also. Now, my son is 15 years old. Always been in my son's life. I have my son half the time. He's with me. And, these brothers are pretty much the same way. Now, it's no case where these brothers are not providing for their child. Just like, in my case, I always provide for my child. All of us, we provide for our child. We just don't need the state, or do not want the state in our business. I don't need the state in my business. I don't need the state to tell me what I need to do. At the end of the day, the state don't care about my child.
Oh, of course not. Of course not.
You see what I'm saying?
Absolutely, of course not. You can see that in the foster care system and the orphanages over here. Of course not. I understand that.
Right.
Okay, I just wanted to have it crystal clear in my mind from where that was coming from, because if you came in on the conversation late, not knowing the foundation of where the brothers are coming from, it sounds like the last part of my comment. But I'm glad to understand that.
Right, and I mean, it can be construed that way. That's why I'm like, I'm not going to say that you're wrong for, how you feel or how you may have viewed what was said. But I know for a fact,
it was just a comment.
Right, but I mean, I know for a fact that it's not a situation where he's trying to get out of supporting his seed. He supports his seed like I do, Rodney does, all of us do. It's just he's in a situation like myself, all of us, where we don't want the state in our business. We choose to be private rather than public people, and have the state dictate to us how to, manage our affairs with our children.
Right.
But that's all.
Right. Okay, I totally respect that. I do remember listening before, where, yes, it does say that the children should honor thy mother and thy father, for thy days to be long prolonged upon the face of the earth. That is automatic, and it is true with the birth certificate and where that is financially coming from. So that I totally understand. So if it's being done in the entire movement of reclaiming what is yours and taking the nose of the state out of your personal business, then I'll say right on with the fair itself. That's good. That's all right. That's all right. You know what I'm saying? It's just that in case there are how do they say, chillins, in case there are chillins or picnics out there listening to what the brothers are saying, not understanding where you coming from, it sounds like, well, Daddy's just trying to find another way to ditch me. And he's just doing it on paper.
Right.
You know, but that's not what it is. Because I'm sure that, yeah. Now, how would I go about doing, can I do an administrative process for my spouse?
I would have to say yes. Anyone that is capable, legally capable to contract, you can actually execute administrative process on them, especially, but it has to be a situation where your spouse has a duty to respond.
Now, if I have the total power of attorney, a permanent power of attorney in place, and the situation has come about where this person cannot legally enter into a contract, but I am his so-called quote-unquote attorney in fact, and I hate to use that word because I know what attorneys are about, but in terms of the document that I have, that does allow me to make certain moves on that person's behalf.
Correct.
Okay, then I'm just going to go ahead with everything I need to do.
Correct. Yes, it does.
Okay. Well, one love, blessings, and
yes.
You know, and I like donating to Hindsight because I think it's oh boy, it's such a precious resource. I pray every day that they don't try to do something so that we can't hear each other.
Right. Thank you, too.
Okay.
You're
welcome,
and I did
brother.
want to say this too before you get off the show. I appreciate you keeping us honest because my thing is this. I understand clearly why you say what you said. We just don't want people to misinterpret what we're saying or to think that this is a way out of providing for your child, because we do not support that in no way, no fashion. You know what I mean? So
That's
I appreciate you bringing that concern.
Thank you very much. Thank you very much for respectfully listening to my question and answering me with the truth, because that's the only thing that's going to get us from where we are to where we need to go as a unit. Peace. I'm out.
Peace.
I yield. Peace.
Thank you. Peace.
You're welcome.
That was hot, huh, baby?
Yeah, that was hot right there. Because actually, you remember that time it was whenever Jonah was up here, me, you, and Jonah had this the same conversation, and I was agreeing with the sister because I was like, the guys that I know that would want to get out of child support, they would want to get out of child support just for paying the bill, not that they're really taking care of their obligations to that child. So I was like in the same agreement with her, but I also understand the other side of that many brothers are out here taking care of their kids because I'm one of them. I took care of my kids whenever they were young babies, whenever their mother wasn't doing the right things. So therefore, whenever I finally got my divorce, I didn't have any child support, any of that stuff, and I had to keep and I was able to keep all of my possessions because I stepped up and took care of my kids. So therefore, it's only for those guys who are honorable, who automatically out of nature, can understand and accept that responsibility of taking care of their children. And I definitely agree that for those who want to be quote unquote deadbeat dads who just want to get out of a bill or just want to get out of the financial, which is not as important as being there for the child, because you can't put a price on daddy being there. Believe it or not, it's not. I only like guys that just give the money and don't be around the child. I think it's more important to be in the child's life to actually educate and mold that child, because that child is really clay. And I think it's our responsibility as men to mold those children, despite whether or not we with the mother or not. We have to set that aside and really look out for our future, our legacies, which are our children. So I definitely do respect the sister position because I was also feeling the same way that this type of information is not for everybody.
That's real. That's real. I definitely respect what she's saying too. Because let's be real about it. I'm pretty sure it's some brothers out there, man, that's trying to get out of it for all the wrong reasons. You know, because to me, the whole child support thing. I mean, it's a topic that I personally I never really try to touch it much because you don't really know the person's intent that's looking to do what they trying to do.
Exactly.
So I kind of look at it like the universe. If your intent is fucked up, the universe want to make sure that child support order stay in place.
Yeah, exactly.
Some people need it. It's just not all of us. You know what I mean? Some people need that shit.
Exactly. Some people need to be babysat. So some people don't.
Yeah.
You know what I'm saying? Because if you didn't babysit them, they wouldn't do anything. But there's a lot of brothers out here that's really doing the right thing. So therefore they shouldn't have the people all because sometimes the women may sometimes depends on the relationship between the man and the woman. You may have that child support on it. I heard that they take people driving license or lock them up. That they do a whole bunch of stuff to them all because of the child support. And I think that's kind of crazy.
That's real. I do too.
You know what I'm saying? But then at the same token, for the guys that are getting locked up for child support, it must be meant for them to get locked up because the Constitution says you can't go to jail for a debt. So therefore, that person is not studying, don't know who they are anyway. You know what I'm saying? So if you can't go to jail for a debt, at least that's what it says in the Maryland Constitution, and child support is nothing but a debt. You know what I'm saying? So you really have to be on top of your studies. Is really more than one way to really add to that child support situation. Only if you're worthy of it and you still taking care of your responsibility. And just like you said, nature take care of that.
That's real. That's real. Like how you broke that down, man.
Yeah, thank you.
Oh man. All right, I'm gonna go to the. I'm gonna bring in the next caller, man. Let's go to 720-326. Peace to the God. Question or comment?
Peace to the gods and goddesses and OMG, oh my gods, oh my goddesses, oh my God. All this is awesome. We are awesome that we come up with Trinity and Pagliaris and combined contracts with everything, HR 192 and whatnot. So that's all I want. Right. I have questions, but I just wanted to share that. This is you, Shell.
Thank you, too.
Well, thank you guys.
Thank you.
And so my question, I'm overwhelmed to some extent because it is so amazing for where I'm at right now that I'm like, oh my gosh, this, that. So the reason is because I had my court case yesterday, and I attempted to get all my stuff in, but I couldn't get it in all until right before the case. It was at 8:30. I got one of them put in the day before, and then the two others that day morning. But so the judge, they actually had a judge. He didn't have my paperwork, and I was saying I'm here and I'm the owner of that and Ligas, but he was like, I've seen people like you before because he didn't see my paperwork. And so they asked if I wanted to do a jury trial because they want to take me to trial, jury, or judge. And at the time, I said a jury. So now I have my jury date on January 11th. So my question is, not my question, but so I'm going to put in either a mandatory judicial notice or a declaratory judgment. And I was at the law library afterwards and trying to figure out which would be the best way to approach to enter in my paperwork all properly. So I have a little time to just send them in registered mail to the appropriate people, and knowing that I need to send it to the 3 people, but also to the lower court that it's actually started in. So my question is, a declaratory judgment as opposed to a mandatory judicial notice or a demand to be heard, how are those different? Like, are they different? I mean, one's to notice and one's to make a judgment. So which would be which, in your opinion? I want to kind of get some opinions to see what's going to be best for me.
I would say that they are definitely all different. I'm gonna start with the mandatory judicial notice, because that's really what you want to use. The mandatory judicial notice is used to notice the court of the documentation that you're putting in. You know, like I know me personally, I use mandatory judicial notices for things like legislative facts as well as adjudicative facts. Now, an adjudicative fact will be a fact that's material to the case. That's what an adjudicative fact will be. And legislative fact will be something like a constitution, statutes at large. Those are legislative facts. So I use, judicial notices or mandatory judicial notices to enter that in as exhibit. So I would say that you want to use a mandatory judicial notice. Now, a declaratory judgment was used. It's actually a form of a lawsuit. In that particular form, you're having the court to declare the rights under a contract, an instrument, even a law. You see what I'm saying? So that's,
like a counterclaim would be more like a declaratory judgment, sort of.
That you can bring it in as a counterclaim.
Okay, but continue. I'm sorry.
Right. No, you're fine. I mean, you can bring it in as a counterclaim. Now, the third one, I'm trying to remember, what was the third one?
Demand to be heard. Like to put in a request to, what was it? I forgot what rule it was. But basically to put in so that I'm heard before it gets to jury, so that it's basically stopped before it gets to jury, because it's not just, because that's where I'm at, I guess. That's that.
Got you. Okay, so I would have to say, because basically you have a situation where you're trying to enter documents. You have pretty much more documents you want to enter in as exhibits. Am I correct?
Yeah, my 5.1, my right to travel, and my facts and rebuttal to the complaint and to the police officer's statement. So I put all that in. I forgot to put in the Colorado Constitution, because I was just trying to pushing my limits and didn't even have a day of sleep, because I was just trying to make sure it was all right, perfect, perfecting it. And then like the affidavit or the where you deliver it, the thing where you sign and say you delivered it, and then with the notary. So having the notary sign all those documents, and so I was trying to do all that and then get it in. And so that morning I only had like 6 hours sleep in 2 days, so I was not really. And, kind of oiled myself and meditated for a few minutes, but I was really exhausted by the time I went there that morning. So, anyways, I don't know why I said that.
Now, the Colorado Constitution, you can bring that in with a mandatory judicial notice. I would call it something like mandatory judicial notice of legislative fact, and then I would use Federal Rule of Civil Procedure Rule 44 to bring that in, where they have to take judicial notice to it.
Okay. Now that's what. So what would be an example of a judicial fact as opposed to the legislative fact? Like an example of that judicial.
You're saying an example of a legislative fact versus a judicial?
I think I'm getting them confused. Yeah,
adjudicated.
Judicial
Adjudicated.
fact.
Oh, okay, yeah, right, adjudicated. Matter of fact.
Oh, adjudicated? Okay, I thought it was adjudicated, sorry. Rule 201 you said earlier.
Yeah, that's Rule 201. Actually, I'm going to pull it up. It'll be a lot easier for me just to read you the definition of what it is.
To make a judgment as opposed to making a law. I think legislative is making law, and to make a judgment on the law that was written in the legislative.
Right. See, a legislative fact is a fact that actually went through legislation. So it would be anything like the Constitution, statutes and codes, statutes at large, those type of House resolution, all of those are legislative facts. But a adjudicative fact is a factual matter concerning the parties to an administrative proceeding as contrasted with legislative facts. It is which are general and usually do not touch individual questions or particular parties to a proceeding. It says facts that concern a person's motives and intent as contrast with general policy issues. It says those facts that must be found beyond a reasonable doubt by the tier facts before the court or before there can be a conviction. It says adjudicative facts of which a trial court may take notice if a fact is not subject to reasonable dispute are those to which law is applied in the process of adjudication. They are facts that in a jury case normally go to the jury. I'm trying to see. All right, here go an example. Here go an example. It says adjudicative facts differ from ordinary facts in that they are considered facts only if the court recognizes and accepts them. Now, if you use federal rules of civil procedure, Rule 201, you can demand for them to recognize them. Under that rule, they have to recognize them. That's why when you bring in an adjudicative facts, I would use that rule. Now, an example of an adjudicative fact is a witness may testify that she saw the defendant's car parked at a specific place at a specific time. These are facts as she recalls them. However, the court may reject her account and instead accept another witness' testimony that the defendant was driving the same car in another part of town at the same time. The second witness' account would therefore become a part of the adjudicative facts of the case, and the first witness' recollection will be considered immaterial.
Oh, okay. That makes a lot more sense as an example to understand it. Okay, that makes so much more sense. Oh, my gosh. Okay. I got that.
Gotcha.
So then I have a question. So if I do the HRR, I don't know why I have it in my head, but the Constitution, and I put that in. Now, do I make, this is the other one with all my documents, do I make color copies of my original, or do I make originals of all of them and send them, or what's the best way that you found when you're sending in your paperwork to do that kind of stuff? Yeah, because there's so many copies. Like, that's like 25, 30 pages.
Right. The way I actually put mine in is, what I do is I make a true and correct copy. Now, it doesn't have to be color. Matter of fact, I'm gonna tell you something funny. I know doing work with Rodney, I used to always put in color copies. I remember Rodney told me one day, he said, man, fuck that. He said, man, as long as it's a copy and it's legible, whether it's black and white, it's still a copy, which is true. So it doesn't have to be color. You know what I mean? It could be black and white, but you want to make a true and correct copy. And what I do is this: I only put in what I'm using. You know what I mean? Because something like, I'm gonna give you an example. Maryland Constitution, the copy that I have is probably about 20 pages. And if I'm only using certain parts of it, all I do is copy the first page with the certification in those sections of which I'm using. And what I would do is put a note or a footnote inside of the actual pleading, telling the court that the originals are in my possession and they can be shown to the court upon request. But that's actually how I submit mine in under a mandatory judicial notice for a legislative fact. That's how I will put mine in.
Okay, so I have a question. When I ordered a lot of the documents from you, so for example, HR 190, I don't know, I think I got it from the other one, but one of them, like the Georgia Constitution. Okay, so the section that says a notary is valid for a court. I would do that page and add that into my document so that I could just show them that my notary is the court or her signature.
Correct.
Or his signature.
But you will do that page, but you also want to do the page of the certification, and even I would even do the page of the attestation also. I would actually do all three of those pages. So I would do the attestation, and then I would do the certification page, because the notary that I had actually attested to seeing those actual documents. You see what I'm saying? And then I would put in that actual section that you're using that states that a commission or republic is a court. And then I will put a footnote inside of the actual document, letting the court knows that the originals that I have are available for review upon request. So if the court
Okay.
want to see the originals, I can bring them in and show them to them.
Okay.
But I'm giving them
Now-
two correct copies of the originals that I had.
Okay, so when you say a footnote, like to say the 3 pages for that specific document I would be doing would be like that original cover letter that says this is the right document with that little ribbon. Then the page of whatever information I'm trying to use out of that paper, and then the notary signature of it saying that that's all true copy. So those 3 pages, and then say, could I handwrite on the original, or do you type in because they're all copies, or do you add a page when you say a footnote, or is it in other pages? How do you use a footnote?
Well, I actually listed in my mandatory judicial notice. Like I'll put a statement like if I'm a defendant, I'll put a statement like, defendant. Give me a second. Let me, because I want to give you proper language. Give me 1 second.
Okay.
See if I can find something real quick. All right. I got one. All right. Okay. I would say something like this. Take notice that defendant filed in this court. This one is a little bit. All right. I'm just gonna read pretty much how this one sort of gets it. Okay, it says take notice that plaintiff filed in the court his respective contract in controversy as an adjudicated fact, and he respectfully demands for the court to take judicial notice of his contract here in the following, and then that's when I would state, basically it's a true and correct copy like that.
Oh, okay. So that's okay.
So you're making it clear to the court that you want to file, basically, these constitutions in. So I'm trying to think, like you'll say something like, take notice that defendant filed in this court. I had to sit down. I'm trying to sit down and I'm trying to word it properly. File in this court, legislative facts, and he demands for the court to take judicial notice of them here in the following, and then I would list the legislative facts like that.
Okay.
Do you get what I'm saying? Because I'm trying to make it
I do.
clear.
That makes perfect sense, because in the rules it says to do it a certain way, and then you make the points, and that's how it says it to do it. You're following that procedure of the way it says to do that, but you're making it clear so they understand what you're saying.
Yes.
Okay.
Yes. So then it's no misrepresentation or no misunderstanding that you want them to take judicial notice to those specific exhibits that you put in.
Okay, so those would be exhibits, because these are things as evidence when you put it into the court case, now that it's going to go to jury trial, as opposed to the other paperwork I I did get in, but they didn't see it, so they did all that other stuff. Okay.
Yes, I would exhibit them.
That makes sense.
So
Okay.
let's say you're using Colorado Constitution as a legislative fact, and let's say you're using the federal Constitution as a legislative fact, and then let's say you're also using the Bill of Rights as a legislative fact. Now, in some cases, me personally, I use the federal Constitution in conjunction with the Bill of Rights. I use them together, but you might, it's an option if you want to separate them as legislative facts. So you would have 3 lines. You have number 1, number 2, number 3, and I would actually, and let's say you had adjudicated facts, you want to put it in there too, like a contract. What I would do is 2 separate mandatory judicial notices. The first one would be mandatory judicial notice of legislative facts, and then I would use Federal Rules of Civil Procedure Rule 44 for that. Now, for the adjudicated facts, I would do a mandatory notice of adjudicative facts, and this will be under Federal Rules of Evidence 201. So the one for legislative, let's say I'm using those 3 documents. I will list 1, 2, 3. Number 1 is the federal Constitution. Let's say number 2 is the Bill of Rights. Number 3 is Colorado Constitution. what I would do is call those like Exhibit A. And then, you see what I'm saying? Then I would number in Exhibit A what numbers is, let's say, the federal Constitution. So the federal Constitution is number 2 through, let's say, 2 through 10. And so I would list it like that. And then I would do the same, for the next 2. And then when I go to the adjudicative fact, the judicial notice on the adjudicative fact, I would actually put that down as Exhibit B, like that. And then and I would give a description of what that is.
Got it.
So I would actually put them in as exhibits, and I would list them as that, and I would even number the pages. I would add my own numbers in it. So so
whatever they are.
Yes. Yep. It's really just an organization method that I use dealing with my paperwork.
Got it.
It makes it real easy to follow what I'm trying to say.
Yeah, no, I understand because I've worked on other documents similar to when I did exhibits and all that stuff for something else a long time ago. So I coming in my head that way. I remember it. So then one last question here. So the notary commission portion of the Georgia Constitution that you mentioned, 1877, Article 6, to put that, would that also be then a mandatory legislative thing to have them recognize the notary on all my documents that we put in? Okay.
Correct. Yeah.
That would just be like C or something. Okay.
Yep. And the notary can adjudicate facts. That's really the whole point of what I was trying to bring up earlier, because when we do these administrative processes, we're actually utilizing the notary as a court to adjudicate facts that you're going to take into a court to get a ruling on. You see what I'm saying? That's why I was saying, like, me personally, the way I write them, I know Rodney does the same thing. We write affidavits and contracts. They're the same thing. We actually utilize our contracts as affidavits. You could put them both. You could put our documents in the same, in the category of both. What makes it the contract is how we serve it on the people. You see what I'm saying? And you can take that into the court.
It. Oh my gosh,
that's what makes it the contract.
Got it.
Because see, an affidavit can be a contract, but a contract is not necessarily an affidavit.
Correct.
It depends on how you utilize the documents. You just got to understand the elements of them.
Okay, and you went over that, or someone did over a contract a while ago, so I got to look that up again and review it. Okay. Now, when you serve for a contract, is that part of like the administrative process? So I would, what's the word? The administrative process where you send in registered mail with all these documents with notary and affidavit and everything we kind of talked about.
Correct. Now, okay. Like let me give you an example of an administrative process. Let's say, I'm trying to think of a really. Oh, let's say you're traveling in your car, right? Mm-hmm. Let's say, God forbid, so let's say you get into a little fender bender, and let's say it's with a company, not necessarily an individual, person or natural person, but let's say it's a company. You get into an accident with an actual driver, and let's say you exchange information, but their insurance company, for whatever reason, decides that they do not want to give you no type of settlement for the injury that the worker of that company caused you from that accident, right? What you could do, because that insurance company has a duty to respond to you because of the connection, because of the accident. They insured that driver for that company. You can actually execute an administrative process, making demands, basically stating the facts of what occurred. And this is all stuff that you want to do before you ever make it to court. The paperwork is the court. This is what some people don't realize. You know what I mean? I just had a family member earlier this week tell me they want me to help them with a suit. It's a small claim, but he told me, and I told him, you got an option. This is the option. I say, you watch Judge Judy and all that stuff like I do, right? Yeah, I said, well, you can go in there and you can argue the facts like everybody else, and let the judge make a ruling based upon the merits, and when the judge weighs what you and that person is saying, or you can do it the way that I like doing it, and you can stipulate it all in the contract. You can serve it on them, right? So affidavit and contract, you can send it to them and allow them an opportunity to respond. You know what I mean? They don't. Their silence becomes acquiescence. You stipulating all that in there. You're telling them that, upon failure to respond, their silence is acquiescence to the facts stipulated herein. And then you could take that in there as adjudicative facts, that you got facts that has already been consented to and agreed, and you want the court to make a ruling on the facts. So now that takes away the argument when you go to court.
You mean on January 11th? So I guess it's all done before then, and then they have nothing to stand on.
Correct. You just have to make sure you stand on your affidavit/contract. You see what I'm saying?
Yeah.
So you want to make sure that you meet all of the elements, and you want to make sure that you can verbally explain the elements, because you may get challenged, not only by the opposing party, but you may get challenged by the judge. So you got to you got to know how to respond to that judge too.
Absolutely.
So,
got it. Okay, that makes sense.
Right.
Well, woohoo! Yeah, Law Library, here I come, baby. That's my Sunday devoted there, Law Library.
Yes, indeed. You know what? For me, the same thing. I kind of try to balance the day between football and the law. I try to do both.
Awesome. Well, I've been injured. What you said about the car accident, I actually wish I would have known that, because I just settled with them. But I'm thinking maybe at some point I might undo my signature, because they didn't really fully compensate me, and I'm still using some of the money that they gave me to get better. So that's a whole other whatever. But anyways, okay, I yield the floor. Thank you so very much. Ma'am, you guys are awesome. I love you guys so much. Thank you. So,
thank you.
All right. Bye.
All right. Thank you.
Peace.
That was hot.
Yes, indeed. You got the good feminine energy this week.
You're right. You are so right, man. A lot of it.
Yeah, that's great.
Cool.
Great.
I'm going to move to the next caller. Let's go to 239-333. Peace to the God, question or comment. 239-333. You may be on me.
Peace to the God.
Peace to the God. Sound like a familiar voice.
Yes, sir. How y'all doing, man? I hear y'all putting in that work, Brother Rodney, Brother Keith.
Hey, what's up, brother? How you doing? Super late.
Is Mike there, too?
Yes. Yeah. What's going on, fellas?
Pretty good.
All right. How's it going?
Yeah, man. I was just listening to you earlier when that guy called up, said about the securitization from the SEC.
Yeah.
Yeah. I'm going to have to get with you so we can go in a little bit more on that, because it's right where we're at.
Right. Exactly. Yeah. Whenever you want to, just hit us up. How's everything else going?
Say again?
I said, how is everything else going? Did you get your appeal filed?
Yes. Yeah, we're still working on it. Yeah.
Okay, great. That's good to hear.
Mm-hmm.
Yes, indeed.
Yes, sir. Yeah. So what I had in mind earlier when you were talking about contracts, now is using the FRNs, that would be considered a contract because we accepted it by using it.
I'm gonna have to say correct. You are correct.
So in essence, we have a choice not to use the FRNs, but we have to find another way. We just have to find another way to make a payment in lawful money.
I would have to say you're correct, because according to HAR 192, it says that the Federal Reserve notes it says including Federal Reserve notes. Let me see if I can pull that up real quick.
Music kind of loud. All right, there we go. Sorry about that. All right, I'm gonna try to put it up real quick. HR 192. Because the way they word it, a matter of fact, it's kind of funny because I was talking about this earlier. Is that Federal Reserve notes is a kind of United States money or United States currency. Pull it up. It's like I'm getting a lot of feedback on the music, y'all. Is it too loud or?
Yeah, it's not so bad. No.
It's not okay. If it is, I'll just turn it off. I'm almost there too. Here we go. All right. Inside of House Joint Resolution 192, it says, now this is B. Now it says, as used in this resolution, the term obligation means an obligation including every obligation of and to the United States accepting currency, payable in money of the United States, and the term coin or currency means coin or currency of the United States, including Federal Reserve notes. So they're telling you that it's other coins and currencies of the United States that's excluding Federal Reserve notes.
Right. So by choice, so part of the contract is us using the FRNs. Technically, then we accepted their contract to use it.
Correct. I would have to say you're definitely correct because it's an implied contract there. Through our actions of using FRNs, we impliedly consented to that contract.
Right.
Now, then let me say this though. Now, the beauty of that contract is that contract is built in duality. Same FRN is also a lawful treasury note. Because, matter of fact, I can go to the Federal Reserve website. Matter of fact, I can go there right now, and because I remember reading this on their website. I think I put in lawful money. Here we go. What is lawful money and how is it different from legal tender? This is on the Federal Reserve website. And let's try to find this real quick, y'all. All right, here you go. It says in 1933, Congress changed the law so that all United States coins and currency, including Federal Reserve notes, regardless of when issued, constitutes legal tender for all purposes. Federal and state courts since have repeatedly held that Federal Reserve notes are also lawful money. You see what I'm saying? So the beauty of the contract is that when you use Federal Reserve notes, you can use it either way. It can be used as fiat currency or it can be used as lawful money.
Okay, but it's knowing that goes back to the public and private, but it's knowing how to activate the private side of it to make it lawful. You'll have to stipulate that.
Correct.
Okay.
Correct. I mean, because I'm gonna tell you, they even have a case up here. It says Milan versus United States, and it's from the Ninth Circuit in 1974. I mean, it may even be a good thing to even get that case law because it says that in Milan, the United States Court of Appeals for the Ninth Circuit reviewed a judgment denying relief to an individual who sought to redeem a $50 Federal Reserve note in lawful money. The United States tendered Milan $50 in Federal Reserve notes, but Milan refused the note, asserting that lawful money must be gold or silver. The Ninth Circuit, noting that this matter had been put to rest by the United States Supreme Court nearly a century before in the legal tender case of Julia versus Greenman, which was from 1884, rejected this assertion as frivolous and affirmed the judgment. So they're basically saying that what I get from it is this: the fact that the Federal Reserve note has the United States Treasury on it makes it a lawful money. And that's what makes our money orders lawful money when we draft them off of the United States Treasury. You see what I'm saying?
Yes. Yeah. But where I'm going with this, Brother Keith, I was looking at if it made sense to do an affirmative defense, non-pro tongue, saying that when you bought a property, you bought it in lawful money, even though you used a check. But then a check doesn't stipulate.
Yeah. I didn't mean to cut you off. I think that's hot, and I think this case law supports what you're saying. This case law right on their website, it supports it. Now the question is, when you bought it, right? The question is this: when you bought it, right? That promissory note can be used as an instrument saying that you owe a debt, but it can also be used as an instrument to pay a debt. Now we know that they used it. It was used to buy the house for. The house is paid. It's already paid for. We know that. But then they put it on their books. See, to me, is even more so an accounting issue because you see what I'm saying? They put the note on their books as a oh God, man! I wish I had Dave on here. They put the note on the book as a debt instrument. I can't remember what side of the book. I think that's accounts receivable. I think they put it on. They put the note on instead of the accounts payable.
It's actually like they're supposed to put it on. Say if they do like a bank entry, say for example, if they take a deposit from you, and by way of a check or a promissory note or whatever it is, they put it on the books as a credit to the bank, but it's also a debit to the bank because if you come back and get it. So therefore that's the other side of the book. So whenever you give them the promissory note, they're trying to make it seem like you're making a promise to pay, but in reality it's your property, so you're actually giving them an asset, and then it's the debit on the other side because you're supposed to go back and reclaim that promissory note. That's what a lot of people are doing now. They're trying to go back and reclaim the promissory note as their property because they know that they did not take the note and hold it as a debt instrument to collect money. They actually took the note and securitized it and made it into a security, and then now if you wanted to reclaim it, that's opening up the other side of their books because they know that we're the ones that provided the energy to the promissory note.
So technically, to take it back, we would have to rescind the original contract that we accepted, that we signed it.
I didn't. It's a variety of ways that people were doing it. I never was one of the. I never went after it that way to reclaim it as my property because I think that's like an IRS issue. As people are doing certain forms in order to claim it, and then people are also claiming it under Article 9 of the UCC.
Okay. Yeah, because I'm reading it right now, and basically all it is a contract, basically, because they basically tricked us into saying that in return for a loan that I have received, I promise to pay whatever amount of money it is.
Right.
Yeah, see, the problem is really the deed of trust. You know what I mean? Because the deed of trust is what they put in place after the actual deed, where they have you pledge over your property as collateral in case you don't pay.
Okay, but that was done after the fact, after signing this contract.
Right. Because the warranty deed is always first. Because you gotta own the property before you can give it away. You know what I mean? That's how you know that one was recorded first.
Okay.
Or at least it should have been recorded first. Yeah, that's another thing. I kind of think that's something that is worth checking. Which one was recorded first? Because the warranty deed is always supposed to be recorded before the deed of trust.
Right, because like you say, you have to own it first.
Right, because you got to own it before you can give it away.
Right.
It's like gifting and leaning.
Yep.
Right. Exactly. Yeah. You have to own it before you give it, because you can't give a deed of trust away and you don't own the property. That's why they get you to sign the promissory note first before you sign the deed or the deed of trust. So therefore they make sure that they trick you into slavery with the promissory note itself, and then they come back and make you pay for it again. And then the way that they make you pay for it, because they actually put your property under the deed of trust and say, well, if you don't pay it back, then you give them the authority to come foreclose on the property. You know, but whenever you actually sign the note itself, the note, and I think you have one right in your hand, Link. It says that for the value that you already received or something like that, and then you agree to pay. But if you ever been to a closing, whenever you sign that note, they haven't really gave you any money, nor have they sent the money to the title company in order to fund the deal. You know what I'm saying? Because the title company, whoever giving the money, they always send the instructions, and part of the instructions is for you to sign all the documents before any funds are released. So therefore, the note is inaccurate, because you're signing it saying that for value received or money received, but you haven't received anything until after the closing is complete. Then they release the funds.
Right. So basically, if we go back to do the forensic report, we can get them on a violation right there.
Right. Yeah. But I'm not sure if you have. I'm not sure what the statute of limitations of actually making that claim. You know what I'm saying? Unless you say that it's fraud.
Yeah, well, that's what it would be. I mean, it's fraud technically.
Yeah, as long as you meet the elements. The one thing about fraud, it's like they committed fraud, but they put a lot of elements to really prove fraud. You know what I'm saying? So that's why you have to go through each element and make sure that you can not only allege fraud, but actually prove it.
Right. Yeah.
I got an idea with the whole fraud. Why not stipulate that they could? Why not stipulate it and accuse them of that in the actual affidavit / contract, and allow them the chance to rebut it? And if they don't,
in the form, yeah.
Right. Yeah, that makes sense right there. I agree.
Yep.
Yeah, that's hot.
You know, thanks too. Yeah. I mean, and I'm like, we got to utilize our power to contract. I mean, we have the unlimited right to contract. You know, and it's kind of funny because it seems like every week, no matter what topic we talking about, we always talking about contract, because everything is a contract.
Everything that we do in our daily lives involves a contract, but we just not seeing it.
You're right. Like basically, prime example. You're 100% right. Check this out, Link. Prime example. Federal Reserve notes. Like you said, using Federal Reserve notes. Isn't that a contract? I'm like, hell yeah, it is. That's an implied contract like a bug, man. Because we use it every day.
Yeah.
And because we involved in commerce, we expected to know commerce. So we expected to know contract.
Yeah, but by using the FRNs, we're accepting their currency to say that we're transacting in commerce.
You're right. Yep.
That's the first fraud right there. That technically that's done without full disclosure.
Right. Well. See, I'm gonna tell you, I feel a little differently about the full disclosure. I'm gonna tell you why. Excuse me. Everything involving their currency is actually in their public law. So they're not hiding the information. It's just people don't go look it up and read it.
Correct.
You know, that's why I can't even really say that these people are not disclosing. I'm like, man, they don't have to tell us that you need to go read, you know, section such and such a statute. You know, they don't have to tell you that. Automatically, it's presumed that we would do it and we're supposed to do it because we're involved in commerce. I must say that I actually agree with them on that shit. It was once upon a time when I didn't know any of this stuff, but you know what? I understand what they're saying now. The fact that I'm an adult and I'm involved in commerce, I have a duty to know what the hell I'm doing. And if I don't, shame on me. I actually agree with that shit. You know what I'm saying?
Yeah, you're right. That's a presumption.
Yep.
I agree with it too. The only thing that I want to add is that they had a duty, in my opinion, not to dumb us down. To whereas once we become the age of majority, even at the age of 18 or 21, that they should have taught us in school how to conduct ourselves in commerce and how to conduct ourselves in law the way that they taught the children back in the 1800s and the early 1900s. Because if you take one of those tests that Ben Carson is talking about, you'll see that all of the exams coming out of the 6th or the 8th grade is like legal and law questions. The college is like everything that we study in now. These kids knew in the 7th, 8th, and 9th grade. So the fact that they dumbed us down and gave us an education that's in total 180 degrees in contrary of what we have to deal with in law, I think that's kind of messed up too.
I agree, but you know what? Yeah, I just want to throw this out there real quick. The Rockefeller Foundation, all those people that was behind this public school system, they don't need intelligent people. They need primitive workers, and that's what they all. That's what they have taught us to be: is primitive workers, so that we could be their slaves. You know what I'm talking about?
Yeah.
And ask no damn questions. We don't know any better. You know?
Exactly.
Yeah, you're right. Because that's where they want to keep us.
Yep.
I mean, I didn't mean to cut you off, but just like we were talking about earlier, I mean, they did a good job with the system. I mean, they got us dumb as a mug. You know what I'm saying? I mean, we are like super crazy. You know what I'm saying? So to as we feel as though that we I think it's good to say that we took the initiative to realize that we've been dumbed down and actually studying the stuff that we should have been taught. And a lot of people, you know, that's not in this movement, if you mention anything to the contrary of being a slave, you know, they'll look at you like you like an alien or something. It's amazing.
You're right. Can I read something to y'all real quick?
Yeah. Go ahead, bro.
All right. It says, energy is recognized as the key to all activity on Earth. Natural science is the study of the sources and control of natural energy, and social science, theoretically expressed as economics, is the study of the sources and control of social energy. Both are bookkeeping systems. Mathematics, therefore, mathematics is the primary energy science, and the bookkeeper can be king if the public can be kept ignorant of the methodology of bookkeeping. All science is merely a means to an end. The means is knowledge, but the end is control. Beyond this remains only one issue: who will be the beneficiary? In 1954, this was the issue of primary concern. Although the so-called moral issue were raised in the view of the natural law of selection, it was agreed that a nation or world of people who will not use their intelligence are no better than animals who do not have intelligence. Such people are beasts of burden and stakes on the table by choice and consent. Consequently, in the interest of future world order, peace, and tranquility, it was decided to wage a quiet war against the American public with the ultimate objective of permanently shifting the natural and social energy, which is wealth, of the undisciplined and irresponsible many into the hands of the self-disciplined, responsible, and worthy few. In order to implement this objective, it was necessary to create, secure, and apply new weapons, which, as it turned out, were a class of weapons so subtle and sophisticated in their principle of operation and public appearance as to earn themselves the name silent weapons. In conclusion, the objective of economic research as conducted by the magnates of capital, banking, and the industries of commodities, goods, services is the establishment of an economy which is totally predictable and manipulatable. In order to achieve a totally predictable economy, the low-class element of society, which is all of us, y'all, must be brought under total control, must be housebroken, trained, and assigned a yoke and long-term social duties from a very early age before they have an opportunity to question the propriety of the matter. In order to achieve such conformity, the lower class family unit must be disintegrated by a process of increasingly preoccupation of the parents and the establishment of government-operated daycare centers for the occupationally orphaned children. It says the quality of education given to the lower class must be the poorest sort, so that the mote of ignorance isolating the inferior class from the superior class is and remains incomprehensible to the inferior class. With such an initial handicap, even bright lower class individuals have little, if any, hope of extricating themselves from their assigned lot in life. This form of slavery is essential to maintain some measure of social order, peace, and tranquility for the ruling upper class. And this is exactly what they doing. They are executing that shit to the fullest.
Economic slavery.
Yep.
Yeah, that's right.
Yep.
Yeah, but you see, they brought it down to a science. They broke it down to a social science and a social structure.
You're right. You're right. Because you know what they need? Primitive workers. They don't need intelligent people. People like us, they hate.
Yes.
They need people to take orders and ask no damn questions. That's what they need.
All right.
Well, we ain't gonna take it no more.
Not at all. You know, this lower class element, because you know what the fuck they talk. They talk about all us regular people. This lower class element is waking the fuck up and changing things.
That's right. Exactly.
You know?
They hit you where it hurts. They hit you when they hit you in the pocket. That's where it hurts.
You're right.
And like you said, they give us FRNs for our energy, and our energy. I mean, you can't pay somebody for their energy. I mean, basically, we should be getting gold for our energy.
Right. Because gold is the energy conductor. But Federal Reserve notes isn't. You know, when they rob the people of gold, they rob them of their energy. That's exactly what they did.
Oh man, we've been robbed from day one.
This thing is deep. This thing is very deep because it's an energy conductor. You know what I'm saying? So when they took the gold, they took the people's energy. It's almost like they took our souls from them.
That's exactly what they did.
It's all about that energy, because if you taking somebody's energy and you giving them a piece of paper that's worthless. So
right.
Who got tricked?
You're right. But you know what I've learned? Check this out, Link. I'm gonna tell you something I've learned, man. I've learned that the power they have, right, can easily be obtained by us by mirroring them. What I've learned is that you got to become a mirror image of them to beat them. So the same way they are, you got to be the same way. They ruthless, you got to be ruthless too. 10 times as ruthless as them.
That's correct.
Now you can stay in honor and do this. You know what I mean? They don't like to follow their rules and shit. You know what I mean? We using their rules, but I mean, as far as going hard, we got to do the same shit they doing, man. That's how you implode. Matter of fact, they showed that in the Matrix. How did Neo win? He had to implode through the Matrix. He had to become it to win.
Yes.
I see.
Yeah, exactly.
Mm-hmm.
Man, that's hot. That's hot.
Well, that sure is.
Well, there's a newer movie out. It's not that new, where Justin Timberlake he's running out of time. He's in the future, and everything is about time and energy.
Yeah, I saw that. That done came out a couple of years ago, to where people will kill you for your little time.
Right, but break it down. In reality, that's all we got.
Yep.
All right.
It is. Our time is more valuable than all that shit. You ain't lying, man.
No, I mean, but think about it. You can't buy time.
You can't. Time is irreparable. I believe I'm using that right too. It's irreparable. There ain't no dollar value for that shit. Not for real.
No, hell no.
You can't get it back.
You can't get that back. unless you know how to reverse it.
Right. You know. Yep.
That's it right there. The most valuable thing in life is time.
Time and space.
Yep. That's real.
That is it.
You know, man, that's hot,
real.
man. That's, you know, we got to make the best use of our time.
We do. And you know what, too, Link? You know, I actually just thought about something. You know how we was talking about the gold, and I was saying that the gold is an energy conductor. And when they took the gold, they took the people energy, right? Well, you know how where money came from. You know, a lot of people know, but money is really like Mooney, because you know gold represents the sun. It's the alchemical energy of the sun, just like silver is the alchemical energy of the moon. You know what I'm saying? And I'm like, what is the greatest energy conductor that we have? It's the sun. You know what I'm saying?
It's unlimited.
Yep. Which tells me gold is unlimited. You know what I'm saying? So when they rob people to gold, they rob us for real.
And they're still robbing us.
And they still robbing us. All our energy, all of that shit. That's why I have no mercy. I don't give a fuck about them people, man. Real talk.
Yeah.
You know what I'm saying? You be the devil by being the devil. Fuck them. You know what I'm saying? Real talk.
Yeah,
you know?
Yeah, that's real. So they definitely don't care about you and your family. They proving it every day.
Yep. Yes, indeed.
Every day. I mean, it's ridiculous.
Well, think about it. When you created the work week, 40 hours a week, they calculate the energy that they're going to give you, right? So so whatever your hourly rate is or whatever your salary is, and they give you the FRNs.
Yep.
So, I mean, you don't have no other time. So, basically, if you were to add up all the time that you put in to get back that energy, you couldn't even come up with the right number.
You're right. I mean, it's like, to me, I mean, when you think about it, it's almost like these people are being elevated to a level of godism. Like let me give you an example. I'm watching the Cleveland and New Orleans game right now. I got it on my TV, right? And you got an owner of both these teams. You can't tell me that this owner don't feel like God, knowing that he got all these people depending on him for a job. I mean, real talk, man. That's a form of godism, man. Real talk.
Yeah.
He's controlling all their energy, all 5 of them, all 10 of them on that court, including the bench. I mean, think about all the people in the stands, man. These people know what they doing.
Yeah.
They just never thought we'd figure out the science.
Yeah. That's why they shut us down.
Yep.
Yeah, exactly.
You know, somebody owns that Coliseum. You know, it's like a Coliseum. Somebody owns that joint, man. And they got all the people housing all those people energy, man, like batteries.
Yeah, but that's what the Coliseum is, though. You remember the rules to use Coliseums, and that architectural design is designed to harness energy.
Yep, that's real talk, man. That's real talk. Mhm.
Yeah. No doubt.
Yep.
No doubt. Yes, indeed.
Man, y'all brothers keep up the good work, man. Y'all keep up the good work. I know we at the end of the show, man, but y'all doing a hell of a job, man.
Oh, yeah, I appreciate it too, man. Couldn't do it without you.
Man, y'all dropping it to where it's making it clearer for a lot of people. You know what I'm saying?
We appreciate that too, man. You know, because I'm like, you know, our strength lies in everyone else and vice versa. You know what I mean? I'm like, we all need each other in this battle, because the stronger each one of us are, it protects the next man. You know what I mean? Or the next woman. That's why everybody has to be strong in this information. You got to be fluent in it. You got to be confident in it. You got to smash them with it. You know what I mean? Because, we're protecting each other. If one man has the information, all they got to do is kill him. And then everybody else will scatter like roaches. You know what I'm saying?
Yeah.
That's the best thing that we can do.
Yep.
Yeah. They can't stop that.
You right.
Yeah.
You right.
Yeah, that's true.
No.
Yeah, definitely true.
Calling in too, man.
Mhm.
I tell you, it was a hell of a show, man. I was like the questions, comments, everything, man.
Yeah.
Yes, sir.
Wow. Yeah, good testimony, good dialogue, good feminine energy from the goddesses. So we hitting on all cylinders.
You ain't lying. Hey, man, I was kind of surprised at all the sisters that called in today. Like, wow.
Yeah.
Normally they don't say much.
Yeah.
You know, that's hot.
Yeah. Well, we need that balance, man.
Yes, we do.
Yes,
those are the teachers. You know what I'm saying? First teachers. Yes, indeed.
Exactly.
Well, I know we're going to get cut off soon, so if y'all get cut off, peace to the guys. Y'all be safe, brothers.
Okay, you too, brother. I appreciate it. Peace to the guys. And thank everybody for coming out listening tonight.
Yes, indeed. Yes, indeed. We definitely do. I know I apologize to all of the callers that's still in queue. I'm going to tell you, the thing about it, and I try to make sure we reach all the callers. The thing about it, though, is a lot of times, when it's through the shows, when you get good vibes and great comments, great questions, it's kind of hard to move fast through. You know what I'm saying? Because, I always hate when it's still people that want to ask questions and I'm not able to get to them. But it's kind of, difficult to rush the spirit of the show. You know what I mean?
Yeah, especially when you got good energy going.
Yeah, Well, you know what I'm gonna do? What I'm gonna do is this. This is what I'm thinking I probably should do, is shorten my intro. That's probably what I should do. Try to shorten my intro at least by about at least 10 to 15 minutes. Because I know normally I don't get on to around 7:30, a little bit at 7:30. Maybe I should curve that to maybe like 7:15, and then I don't know. I'll figure something out with that.
Yeah.
Yeah. But it's all good.
Exactly. Yeah, we'll work it out.
Yes, indeed.
All right, I appreciate you having me on, man. Thanks a lot. This young was hot.
Yes, indeed. Ain't no problem, man. This show was fire.
Absolutely.
That's a bet. All right, y'all. Peace to the gods. Thanks for coming out to another hot show.
Peace to the gods.
Peace.
Work, yeah, you know I got that work. I'm why baby mamas leave. I'm why baby fathers turn. Maybach music. Yeah, made it big with go-go, and I made it with that dough flow. This one right here for DC, this one right here for Polo. See my PA Palace flow, Hugo Boss New Balance flow. Here they keep her close and tempted, thinking rational. Babe, that I get like 8 of them. They clapping and we ballin', oh how fitting we at stadium. BOA,
Lil G, Mo, Cobain, and Trey. Floor T-Side, that Wizards game. So close, I can get flipper play. My mojo back, Majors go bring hobo back. Shout out chicken, getting chicken like my Northeast homies fat. Who that she fool with? He don't do it the same. Baby girl, I just move him. I got that coming game. Who's on my line? Who's on my line? I'm blowing up. These calling me. I snatch your girl if she's slipping. She's on my line like I'm fishing. I got that work, 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 work. Yeah, you know I got that work. I'm why baby mamas leave. I'm why baby fathers Kurt. I snatch your girl if she's slipping. Double MG, not to mention we got that. Riding round, I got some tossing bait. She say I'm a hotter way. I get her off like a holiday. Yeah, that girl is thick, top heavy for days. That bottom heavy. What you a mermaid? Getting on my level, Joe. Nouveau, new and yellow too. They not pulling like smoking when that Rello broke. Never did I pedal, but Tony Lewis said I'm dope. And Tony Jr. said I'm the whole big homie. Hope said I am close. And I got that bait. They all bad, and they gon' fall in out of the hub like my partner Tag. They need something to keep, I need something to grab. That's the end of my speech. I'm